Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will
relevant.
bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
We're getting commentary on the case. Dati mihi Anglican po.
Is that correct?
I didn't ask you to interrupt me. Oh, for Trump's sake.
All right, we're back. We are back for more. I'm trying to avoid all the low-hanging fruit jokes that are just plentiful, abundant. Welcome. It's good to have you here. We're going to be going back to court in just a minute. I have to first of all welcome the one, the only, Cindy Stovall. Hey, y'all. You were first in chat today. We're going to punish you for your promptness. Everything up here related worldwide is your responsibility, including whatever jokes get made in chat today. That's also your fault because it's on the internet. So, answers to the thing. Good. I guess we could say this segment of the show is sponsored by Depends. Not really, though. Although it's for the first time it could be. This has been a big steaming pile of poo. This entire trial has been just crazy. How big do you say?
It's bigger than you. It's bigger than me. It's bigger than all of us.
It's that big. It is. This has been a mess and a half. Well, it's been bad enough that I had to hit the bottle. This is my leftover from driving to the airport at 2:30 in the morning, or driving from the airport at 2:30 in the morning. So I saved it, but I needed it for this afternoon. What if the mods can't help making jokes? I know. It's where we live here now. Jade, thank you very much. 21 months makes you an OG. Wednesday, we're through Recovery Addicts is, your belly will hurt a little bit. Yeah, good to have you all here as we're about to kick off the... We've got a couple minutes, but we're going to be going back to court here where they've already got the live stream up and going. Surprisingly, they didn't delete the last live stream that had all the other stuff going on. Is this just working? Is it just working normally? Last night, as I was driving to the airport, my son, who's the smart one, not that they're all smart, but my son, who's the smart one about programming, I was talking to him about different options. And I suggested an option from way back in the day, like when cell phones were first a thing. I'm like, what about this tool? And he looked it up and he's like, hang on, let me look into it. And I'm like, have you found it? He's like, yeah, I've already set up an account and linked it and programmed it, and I'm just doing a webhook right now. And I'm like, whoa. So I think he fixed it. Defendant's making it worse for himself, in my opinion. How much worse? Much, much worse. So he's innocent, right? Well, in his mind, he is. The jury, he was convicted by a judge. Apparently, he says all the juries have found him not guilty. So I wasn't trespassed from the airport. I was so good at the airport. I went there. It's midnight, right? It's midnight. We're standing in the airport. Just to give you an idea of how slow it is at the airport. Planes don't leave at night. The TSA, the check-in station, is closed. Doors are closed, locked. Everybody's gone home. You can only come out of the airport. You can't go in as far as like in the concourses. And I'm walking around, and it's like a ghost town. Everyone's whispering because it's like a library. It's like, don't make any noise because half the people here that are here are sleeping, and they don't want to be here. Don't wake them up. And there are abandoned luggage carts everywhere. There was one spot where there were 5 of them, like, a little herd. They had gathered together like for warmth or something. I don't know. and they were just sitting there. And I'm like, that's $1.25. I said to my daughter who was there, and she's like, can we? I'm like, no, because it's a crime, apparently. We didn't return any cards. All right. Anyway, we had some fun, though. It was great. My future daughter-in-law. Don't tell anyone. I think it's like not till this next weekend that it becomes official. She was here, so. All right. I was not returning cards for the deposit. Not this time. No, it wasn't. Recap. I'll go back and just briefly wipe over some of the details. Just a little bit. A quick little cleanup of where we've gone in this case. This was supposed to be a pen attack case, a prison pen attack, like prison pen pals. Well, this was not the pal part. This was just the prison puncture part, and apparently we were wrong. We were so wrong. Although the pen has been mentioned a mighty like 60 times or so. 56. I was close. The star of the show, the big kahuna of the show, the main event, has been more scatological. Is that a word? It's the poo. It's the poo. And the poo is, there's a question of whose poo it was, where it was, and who put it there. All these are facts that are in dispute. The state says it's the defendant's poo. The defendant says it's Ricky's poo. The state says the defendant put it on there being on an officer and the walls. The defendant says Ricky put it there, and there was none on the officer. And he has an axe to grind. He has he's got beef. He's got beef with the COs. He thinks everyone's out to get to him. This is a big conspiracy. The judge is involved, which is why he's suing him in federal court, and why he's appealed to the Supreme Court, and that's pending. Those usually don't go well, just statistically. I'm not saying that he doesn't stand a chance, on the merits of his case. But the details are foul. They use the term dash. I dashed the officer. That does not mean I ran to the officer, or I made a hyphen at the officer. A dash is a dash is a splash, right? Like you add a pinch of salt and a dash of something. A dash of vinegar, or a dash of I was thinking balsamic vinegar, or white wine, or when you add a dash of something, a dash of milk, for me that's like 1 gallon. Glug, 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 glug. That's one dash. Apparently you can also do a dash of urine and feces, and that's the dash they're talking about here. So they had to go there. Flushed out the details. Yes, we have been watching this case just spiral and circle the drain for quite a while, as we're waiting for this all to come to a stinky solution. How does that milk commercial go? And then add poop. I don't remember that one. That's before my time. Don't forget, is pee or not pee? So now we can add some Shakespeare to this. We haven't really got touched on Shakespeare. We've done Dr. Seuss and Edgar Allan Poe, but to pee or not to pee, that is the question. We've got a lot of questions about what it was and where it was. So if you have a Shakespeare reference that would fit with this trial, now's the time to just drop it in chat, drop it like a hot potato. Or like you drop your kids off at the pool. Whatever you need to do, just drop it in chat, and we'll go ahead and read those now. So, poo by any other name. Oh. Let's see. Don't get me started if we play words, play with songs. It's all fair game here. This is I will tell you this. I'll make you this promise. There will come a point where the mods and I will lay down the law. We'll put an end to this frivolity and silliness, and say, please focus on the case. Please don't keep the toilet humor where it belongs, which is out of our chat. Today is not that day. Today is not that day. We ask that you not be so crass and crude that little children have to have a long talk and explanation from their parents as to what they accidentally overheard or saw on chat. But if you've got something funny to add as we're watching this ridiculous case play out, boo for my kingdom. Let's see. Just don't be gross. That's it. Just don't be gross. It's gross enough as what we're hearing in testimony in this. Anyway, the Tempest. I'm still sore. I'm still sore from the other day. I didn't know you could. I feel like I've done like 100 crunches, which is a lot for me. Okay, I don't do crunches. I feel like I've done 100 like proper, real crunches, nonstop, while holding, wearing the ankle weights and holding like a dumbbell over my head. I am so sore from laughing. It's probably the best exercise I've ever had. But a couple of you are a little sore as well. The humor is fantastic. We love it, especially when there's some really heavy stuff going on in the world of true crime. Oh, my goodness, it's tough. And I know a lot of you came here for a reprieve because you like true crime, but maybe some of the other cases that are out there are a little much for you. We're not going there. We're not going to Clancy. Apologize if that's what you came for. We will follow other big cases soon in the near future. Right now, we're in the restrooms. We're in the bowels of justice here with Judge Stevens. So let's do song titles today, please. Let's do song titles for this is going to be great. Band names and song titles. I think you have to group the two of them together, right? I think you can't do song titles without including band names. So, Grainers has gone straight into movies as well. This case is exactly what we needed. We've had some rough ones, and I owe this to the mods. But at the same time, thank you, mods, for your patience in all this. What do you think about Koberger? I think he needs to have some evidence. First of all, I've heard that his attorney, Ann Taylor, is filing a response. Has filed a response. I have not seen it yet. There's talk about whether him throwing her under the bus is a de facto waiver of privilege. I don't think it is. I think that's only he can waive that. And I mean, look how many times we've had attorneys that get, he's like, I want to get rid of this attorney. He's lied. He's a liar and everything else. And all the attorney can say is, Judge, we have these irreconcilable differences. I don't think it just ungags her and it enables her to just say everything and just lay out the receipts for how things went down. But he might, especially because he says he's got witnesses, he might have enough evidence to say, yeah, in the light most favorable to the moving party. Well, the non-moving party is what you normally do, right? You might have a reason to have this reconsidered. There might be a hearing on that. And if you can get a hearing, you can possibly win some points during the hearing. So it's possible. I'm not going to rule it out. I don't think it's very likely because I think it was quite clearly covered in detail when the judge took his plea. And he asked all the questions that Brian Koberger now is saying have different answers. So were you lying then or are you lying now? We've got a credibility issue. When he says, did anyone promise you anything to take this deal? And you say no. And then afterwards you say, hey, they promised that this would happen. It didn't happen. Then they promised you something. So did you lie under oath then or are you lying now? I don't know. It could happen. Look how many people have got new trials. We might have the Rose Petal murder, a new one. We've got Letitia Stout getting a new trial. Just people who we never thought. What's the guy's name? husband-wife duo kept the body in the roof in a bag in the ceiling. Poor girl. Yeah, there's just been I'm missing what's happening in the chat. It's probably for the better. Anyway, so your question, what do I think about Kohberger? I would like to see it. I was disappointed. Only that I like to watch the process, and we don't get to see much when there's a plea deal. So for transparency, for putting conspiracy theories to bed permanently, shutting down the noise that pollutes sometimes the world of true crime with the crazy alien talk and everything else, that part can be tamped down just a little bit by having a trial. I'd like to see that. I think the families, at least several of them, would like to see this go to trial and have their day in court, have the evidence laid out, and the state prove that he did this instead of getting a sweet deal that avoids the penalty he's so scared of. So I would like to see it happen, but I can't speak on the legal merits of it. Really, it just sort of depends how the judge is feeling and how the evidence is played out. Justice was served by plea. It was. I can't say it wasn't just. I'm personally, I was looking forward to hearing some of the details after we poured so much time into that case and learning about it and asking questions and still wondering what happened here and what did they know, what haven't they told us. I was hoping to see some of that. Obviously, that's my desire to see the evidence in the case doesn't rank very high on anyone's list of whether or not it should happen or not, but we'll see. The toilet zone. Do. The world needs noise. There's a lot of it, though. And some of the noise is just, I would rather have a kazoo choir of kids before some of the noise we've got out there. It's just, we don't need dissonance for the sake of dissonance, I think. I think he wants death row instead of Gen Pop. I think he definitely feels the grass is greener on the other side of the aisle or in the other cell block. He wants to get away from some of the other prisoners who are giving him a hard time. I'm not sure. I don't know if he wants his moment. He wants to relive the crime and have it read out for his own personal fantasy or something else. I don't know. I don't know enough about him. He's enough of a blank slate in court that A, he scares me, and B, I just don't know. He might be a professional, somebody who can really pry into somebody's brain and how it works might be able to tell us that. But I don't know if that's his driving factor. Let's see. The toilet zone was much better after Ari did his music. Let's see. You guys are still putting... There's so many songs. I thought BK was on the same block as Daybell. I wonder if they've met. Maybe the vegan food is bad. I can tell you one thing. Prison is not going well for Brian Kohberger. And whether he's on death row or not, whether it's just LWOP, he's not liking it. And it will continue to not like it going forward. We'd love to cover Sarah Grace Patrick starting Monday out of Georgia. We'd love to. Let's see. You sent something on the burner? Northwest, let me take a peek.
You are banished from the state of Georgia.
When you say People's federal filing, you were talking about this defendant in this case right here in Texas. Raymond Ronald Peoples Jr. versus the director of Texas Department of Corrections. It's a civil action. It's actually typed. What's the dates on this? It was filed July 16th, 2025, so a year ago. Now, this is the judge responding. As a result, a certificate of appealability shall not issue in this case. Yeah, he can't appeal. He lost it. In this case, the petitioner has not shown that the issue of whether his petition is meritorious is subject to debate among jurists of reason. That factual and legal questions raised by petitioner have been consequently resolved adversely to his position, and the questions presented are not worthy of encouragement to proceed further. So he lost on that one. But we're going to be coming back to court here momentarily. I think might be at 2:30, so we might have just a few more minutes, 7 more minutes or so. Who said we were out of poop jokes? I appreciate you, JMR, for keeping the poop jokes as clean as they can be. We know there are a lot of that aren't appropriate for here, so let's continue that. In the house, fantastic disco nap. Napping at the disco. I've heard of panic at the disco, but napping is something else. Did I miss that? What does that mean? Habeas pupus. Oh, my goodness. Did People's Hand write this? No, that was the response. That was the judge response to his appeal. Let's see. Josh telling us about the upcoming case with Sarah Grace Patrick. In the latest hearing, the defense tried to get a delay in Sarah Grace Patrick, but that got denied, so I'm pretty positive Sarah Grace is still a go on Monday. Might have to do a little check with the court here. Born in the USA. Oh, my goodness. If you missed it this morning, we had an incredible hot mic where the judge ordered a break and then stepped away, left the mics hot, and the defendant, the prosecutor, the witness, and I believe the bailiffs just continued talking about the case. Sometimes with each other, sometimes at each other, sometimes with some of them out of the room. It was the most inappropriate and funny hot mic moment we've ever heard. It was he did say sharp break. And I know he's got a little bit of an accent being down in Texas, but judge left for a sharp break, and that all happened. Poop hit the fan. It's worth going back and listening to if you missed it. We might need somebody to pin it. You know how you can do that in your comments? You can pin and leave we need somebody to pin that moment in a comment, and we'll see if we can. I can pin it. You just send the comment with the moment. Let's see. He said 2 p.m. Central. I'm in Central Time. They give him a 2-hour lunch? It's a long lunch. What are we going to do for all this time? What do you want to do? Let's check and see. Let's see. Domestic violence up in Thurston. We're going to skip that one. Judge Webster, she's done with her gear. She might actually be back. We're right about the lunchtime hour, so. Okay, let's see. Judge DeSanto has a hearing going. Let's see what this one's about.
Okay, thank you. And so as to the arraignment counsel.
As the arraignment counsel, we wait for him reading stand. My client's been advised of his rights and the nature of the charges. He understands them.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then ask the pretrial counsel.
As the you want to?
Sure.
Go ahead.
Your Honor, the people are moving to nollie process matter. I've spoken with the victim this morning by telephone, and they indicate that they do not wish to press charges.
Okay.
There's no restitution in you.
That is correct.
No victim, no crime. Is that what they say? If you don't have a willing victim, at least willing to participate in the process, it might be hard for the
All
state
right,
to
the
prove
court will
some
grant the
crimes.
no-way press, and you are all set. Have a good day.
Thank you.
Good luck to you, sir. We are on the record in the matter of the city of Wyandotte versus Shernay Reader, 26737 A and D.
Good afternoon, Your Honor, John Goldclough, P. 0758 on Streeter. Please put your name on the record.
Lorraine Reader. All right, good afternoon. And today is the date scheduled in this matter for the arraignment and pretrial in council.
As for the arraignment, Your Honor, should stand mute to the charge, waiver form reading of those charges, ask the plea of not guilty be entered.
Court waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then ask the pretrial counsel.
As for the pretrial, Your Honor, I've had an opportunity to discuss this matter with prosecuting attorney. It's my understanding that in return for a plea to the charge of no operator's license on possession, the people would move to dismiss the no proof.
Who's
I
CNN?
discussed it with the Constitution. I understand that I believe in this, but waiting for the rights. I've also explained to her any sanctions from the Secretary of State regarding any driving privileges. With all of that said, Your Honor, she wishes to avail herself of this plea opportunity, and there are no immigration.
Okay, and so, ma'am, please raise your right hand.
Okay.
Do you solemnly swear affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the
This
truth?
is a little bit boring, so we're gonna see if we can find something else to watch while we wait for Judge Stevens to come back. Who's Credence and Mikey? We've got a chase, guys. There's no way the judge shut it down for them doing something. The Judge McNally is all over the internet. Their entire channels. I think there's even a channel called the Judge McNally channel that just reposts all his videos. He's everywhere. Maybe that I would think it's the Judge McNally channel before it's anybody else. I don't think CNN would do it. Law Talk with Mike goes there a bunch. We've got we're there all the time. I think somebody just clicked the wrong button and shut the channel down. Mary Poopins brings a whole when you think of some of those older classics. Not Mary Poppins, but what was it? I was thinking of Singing in the Rain. I think it's called Singing in the Rain. Makes you wonder. That's not rain. So let's see. One of my frequent flyer accounts. Oh, you can't do that to Pippi. Pippi Longstock. Oh, those are good books, by the way. Everyone needs to have a horse that they keep on their roof. Ali G, I can't read that one. I have a rule, and that crosses the rule. Poopy poopy bang bang. Yeah. Let's see. I was looking for something for you. Sorry, I got sidetracked. Okay. Still doing domestic violence up in Thurston. You know how people say that a boat is a hole in the water you throw money into? I can see that, right? Is a jet ski the same thing, or does that get you around the problems? Because I've got this dream of owning a Fish Pro jet ski, which is like a mini boat that you ride on top of instead of in. But it's all designed for fishing. And it's just, is that still like just a financial don't do it type thing? The reason I ask is because this dude, let me show you. Top left, right above me, right up here. Up there. That's the one I want. That's the Sea-Doo Fish Pro. Anyway. It's a slower drain. Bust out another 1,000. Sea-Poo. Yes. I'm just thinking that the one, when I first looked into them years and years ago, they're amazing. I mean, they've got a fish finder on them. They've got GPS, rod holders, coolers, ice, extended gas, so you can run all over the place and not run out of gas. Just really cool. And I'm thinking maybe one of those old ones now would still be worth fixing up and using. The new ones, they want as much as they want it. It's like a car. It's buying a car, and granted it's a boat, but they're a lot of money. I can't justify that. I really can't. I'm sorry, little child. Yes, I had to trade in your college funds for a jet ski so I could go fishing. I haven't been able to sell it to my family that way. Buy a canoe. Northwest, you're hitting a soft spot with me. I had a kayak before we moved out here. It was 14 feet long. It was amazing. It was a Sun Dolphin, I think it was. Maybe it was 12 feet. I think it was 12 foot. 12-foot Sun Dolphin right on top kayak. Loved it. Absolutely loved it. Took it all over the place. Dragged it up and down hills into rivers and lakes and fish ponds. Just all over the place. And when we moved, my wife said it's too big. It costs too much to, we'd have to buy all this extra footage in the trailer to move your kayak. Just sell it or give it away, and you can get a new one when we get there. I still don't have a kayak. And it pains my soul. But yeah, I don't know. I'm also at the point where I'm not sure if the jet ski, having the power option is just more fun. Loves True Crimes, the boat fund. Thank you. The boat fund. We're going to start that little jar and start collecting. It's going to be in one of these empty Mountain Dew bottles, I'm sure. Thank you very much. Appreciate your generosity. My Sun Dolphin is a 10-foot sit-on-one. I love it. Sun Dolphins were great. I had the 12-foot because it can be a dual passenger, so I could take my kids with me, and I've got some great pictures of taking the kids out on the. And it's so stable. I mean, it's not one that you could stand up and fly fish on. It wasn't like that. But if you're main seated, you had to work to fall off the thing, and even if you did fall off, it still probably wouldn't tip over. It's just that good. So your wife owes you a watercraft. This is how I see it right now. Loves True Crimes, thank you very much also for gifting 5 memberships. Appreciate your generosity. True story, says just Stephanie W. Looked out my window to see my hubs and nephew pulling a boat on my front lawn. Yep, we now have a butt. I didn't misread that. I promise. I didn't Stephanie, all your talk during this trial has told autocorrect that well, you meant to say boat. You really said butt, which is great. I love it. There are only 73 jet skis in the entire United States that aren't currently for sale. So I should be able to get one at a good price. Stephanie, I needed that laugh. That was funny. All right, we might be another half hour. Finding Nemo says it's a butt. Oh, okay, Finding Nemo. That's a good reference. I missed that one. It's a butt. It wasn't a typo. I just missed the reference. Kayaking seems to be the trend on the lake I live on. I can tell you that the stand-up paddleboarding is not for me. I know this because also what is not for me is using those two-wheeled hoverboards, death on wheels, whatever they are. They were not designed for someone with my balance or lack thereof. And a paddleboard is like one of those, but add greased lightning to it. Segways, Segway, because it has like the knee brace, I could probably do a little better. He touched the butt. Everything in context. Looks fun, but I don't enjoy standing. It seems like it's a core workout more than I would enjoy. But all right, still waiting for court to start. I think the judge is stalling just so this guy can't take all day doing this. Judge said 2 p.m. So we've got 22 minutes. I might have to find something for y'all to watch. Let me go back to the hunt. See if we've got some courts coming back from lunch that might be doing something interesting while we wait for the poop slinging contest to continue. Could skip DeSanto for now. I know she's still up. Who's this? Judge Joe Lee, Elk County docket. Let's pop in the 13th.
So
I don't know if I can afford an attorney, honestly.
are you seeking the court to appoint one?
State
Yes,
of Kansas
please.
here.
Okay.
13th Circuit.
Where are you at now?
I'm at work at Moline.
Okay. Can you get somebody to give you a ride there today to the courthouse? And how?
Yeah, I think I can.
All right. Well,
pretty sure.
following this hearing, contact the clerk of the district court. Their phone number, if you on your
Oops, hang on. Let me get a pen here. Okay, district court.
Clerk of the district court, on your screen, depending on how it's set up, there should be, it looks like a business card, and there are 3 phone numbers. The top one is Elk County District Court. Do you see that?
I cannot read it at the moment.
It is 620-374.
675-3099. No, this is a public number. We can show this one.
Okay.
And you can contact them. They can put you in contact, or they may be able to electronically forward that application to you, but you need to do so in the next 2 days, today or tomorrow.
Okay. All right.
Courthouse is closed to the public on Fridays, which you're probably aware. But you need to fill that out completely and accurately and submit it. I'll review it. If you meet the criteria for a court-appointed attorney, I'll appoint an attorney to represent you. But I'm going to set another hearing. I'm going to enter a plea of not guilty for you, so you have an opportunity to consult with an attorney. If you wish to change that at a later time, you may do so without penalty. I'd ask the clerk to look for a date for a status conference in approximately 30 days. While the clerk is looking for a date, I will, after you submit that application, you need to contact the clerk of the district court in a few days after that you submitted the application. They forward it on to me. I'll review it. If you meet the financial criteria, I'd appoint an attorney to represent you. You need to follow up with the clerk as to who that appointment is, who the attorney is, and then you need to, as a condition, your bond will be that you follow up with your attorney so that you're prepared to go at the next hearing.
Okay.
Various things that can be dealt with at a status conference. It won't be a trial date, but if after consulting with counsel, if you're wanting a trial, then we would be scheduling that probably at that conference there.
Okay.
Judge, we can
Yes.
do Tuesday, August 26th at 2 p.m.
August 26th at 2.
Yes, sir.
All right. Any objection by the state? Hearing no objection, that'll be our court date. All right. Anything further, counsel? Ms. Lee, any questions that you have?
Nothing no, sir.
From the state.
All right. For the record, while the defendant and I have the same last name, we are not related. Do you agree with that, Ms. Lee?
Yes, sir.
Okay, thank you. So
Lee is actually my married name.
Well, there's no relation there either. So,
yeah.
All right. That one county I used to work at, there was a deputy and a pair of twins that were in court fairly frequently.
Oh boy!
Whose all's last name was Lee, and it was
all in
the family.
Somewhat difficult to get through a hearing. All right. At any rate,
they're like, Dad.
So you've got your court date. Yeah. Following this hearing, contact the clerk and make arrangements to get that application and fill it out completely. And
okay.
We are adjourned. Thank you.
Thank you.
Oh, it looks like he's like completely adjourned. They're all going away. Gone. He gone. I'm hearing you guys talk about these courthouses with no food options. Isn't that like just a business opportunity waiting to be discovered? All you need is like grandma's Italian recipes and a little bit of money to buy some pots and pans and some noodles and marinara sauce, and you're in business. You could go make yourself up a mean courthouse spaghetti bolognese. And of course, if everyone got sick, they'd be looking at you. So, got a Coke from the courthouse vending machine. I was surprised. I'm trying to remember how much it cost. I think it was just 75 cents. That price said buy out the machine. Normally, it's like $1.50. When you go to like a road stop, what do they call them? A rest stop. And we did this when we drove across the country. When you go to a rest stop, they charge like $3 for a can. It's ridiculous. And then if you use your credit card, they add a service fee of like 25 cents, for the convenience. I noticed that almost all the rest stops were run. The contracts were run by organizations that had something for the blind in it. Is there a law somewhere that says that if the organization is helping individuals who are blind, that they get priority consideration for contracts like that? Or, I mean, why are the blind people just getting roped into this because no one else would do it? I don't understand how it works that way. Yes, the vending machines at rest stops, used to love those. It's cool. I mean, I did my Eagle Scout project to help the blind. We were working with a library for the blind where we were fixing and replacing batteries and testing tape recorders that would get sent out to people so they could listen to books on tape. This is I'm dating myself. Back in the day, they can't see it coming. Yeah. How are the bathrooms at rest stops? I've graded them. I can tell you, West Virginia did not do well at all. Like, if it's at all possibility to hold it till you get to the next state, I'd recommend it. It was not good. Regier is live. Let's check and see. Kansas, he's 13th as well, right? one's not. Where did Regier go? I need to fix my algorithm. I've got so much just sports stuff in here. I don't want to watch anything to do with sports. We've got Minecraft Court is live right now. Hang on. Yes, and the court recorder is standing, as she always does. I think she actually hates to sit. She's part statue. The leg part. Prosecutor's here, defense is here, defendant with Shackles is present. We're just waiting for the judge to come in through the door. This judge has the entire sound system rack, audio rack, behind his chair. That's that big robot-looking thing next to the American flag. Typically, those are mounted in a concealed area where it's not just on display. But I guess this courthouse was an older one that didn't have a closet available for that, so they used the judge's area. Here he is.
Thank you, Your Honor. We're here this afternoon in the state of Ohio versus Paul Bradley, case number 26 CR 972. The defendant is present, open court, represented by his attorney, Mr. Lawson. We are here today for the purposes of a pretrial. On July 20th of this year, the defendant was indicted in a 6-count indictment. Just this afternoon, the state did extend an offer to count 3, involuntary manslaughter, a felony of the first degree with the attached 1-year firearm specification, as well as count 4, having weapons while under disability with no agreement as to sentencing. Full discovery in possession of the state has been provided to counsel.
They extended a plea deal. Is he taking it?
Mr. Lawson?
Good afternoon, Your Honor. Takell Lawson, Takell, last name LAWSON, Supreme Court number 0106739. I have had the opportunity to discuss the plea offer with my client. My client at this time will not accept the plea offer. It is our intent to file a motion to suppress and have a suppression hearing later down the line, and we are still waiting on an autopsy report to determine the cause of death of the minor child within this instance. Thank you, Your Honor.
All right, with regard to the autopsy report.
Thank you, Your Honor. The Cuyahoga County Medical Examiner's Office told us that it would take approximately 8 weeks from the date of this offense, which was May 15th, last Thursday morning. After receiving multiple non-response from their office, I did submit a subpoena to their office. We give them 14 days to respond, and I am going to follow up on that at the end of this week.
All right. Mr. Bradley, do you understand what the offer is in this case?
Yes, Your Honor.
Any questions about that offer?
No.
All right. So, Mr. Lawson, you'll file your suppression motion by August 12th, is that correct?
That is correct.
All right, then I'll give the state 14 days to respond. August 26th, we'll set a hearing on the suppression for September 9th at 9 a.m. Anything else, Ms. Contour?
Nothing further, Your Honor.
Mr. Lawson?
Nothing further, Your Honor.
All right, we're adjourned.
All rise.
Wow. It's a big case. He was just offered a deal to take a guilty on 1 count. He says, nope, we're going to try to fight the evidence and wait for additional evidence. But it sounds like there was a death of a minor child involved. We don't know much more than that. And they're done. That's how Minecraft Court ends, with everyone just standing around. Still waiting for Judge Stevens to come back to court, so let's keep popping around the horn here. Let's see.
If you do make bond, probably be a good idea to call Mr. Ketley. Let him know you're out and follow any reporting instructions he may have while this matter's pending.
Okay.
Mr. Baca, anything else on this case?
Nothing from the state, Your Honor.
All right. Mr. Johnson will be in recess. Have a good day.
Next. What's a co-ed jail? Hello,
Good
ma'am.
afternoon. Is it Billia?
Bullia.
All right. There's two cases, both entitled State of Kansas versus Bullia Lorraine Klein, 26 CR 157 and 26 CR 255. In 26 CR 157, you failed to appear
FTA.
on Judge Ricky's preliminary hearing control docket. He issued a bench warrant, bond forfeiture, and ordered a no bond hold. I'm going to put this back on his preliminary hearing control docket. Your hearing date will be September the 8th at 2:30 p.m. That'll be done by Zoom. September 8th at 2:30, no bond hold.
Your Honor.
James Watts continues to represent you. If you wish to seek modification of the bond, you'll need to go through Mr. Watts and get that back in front of Judge Ricky. All right, 26 CR 255. This looks like a new charge.
I didn't realize there was two.
Yeah, this is a new one alleging that that's violation of a protective order alleged to have occurred between June 20th of this year and July 8th of this year in Butler County, Kansas, alleging that you had some sort of contact with Aaron Brewer, even though as a condition of bond in the 26 CR 157 case, you were ordered not to have any contact with him. That's a Class A person misdemeanor. This case is Judge Webster's case. You know, there's a no bond hold that she set until you see a judge. You're seeing a judge now, Mr. Baca. Do you have any recommendations for bond in this case?
Your Honor, can I please just say that I do understand that I have.
I'm seeking a bond recommendation from Mr. Baca on this case.
I just wanted to tell you guys, I did bring myself here because I found out I had a warrant and I did turn myself in.
Okay, I appreciate having that information. Mr. Baca, your recommendation?
Yes, Your Honor.
Advocating for herself.
Well, Your Honor, not looking at any significant criminal history. Certainly have a concern that she has the other case still pending. I think based on that, at this time, the state's recommendation for a bond amount in this case, we would recommend a $2,500 cash or surety bond at this time.
What town do you live in, Ms. Klein?
I live here in Butler County.
Okay, I'll set a $2,500 cash or surety bond in this case. However, you still have the no bond hold in the other case. As a condition of bond in this case, you're to have no contact whatsoever with Aaron Brewer.
Or any of the Brewers.
Okay, Your Honor, you said in order to talk about the first one where I have a no bond hold, what do I need to do to
That'll have to go back in front of Judge Ricky. He's the judge who set the no bond hold. You've got an attorney in that case who's Jim Watts. I'm going to appoint Darren Patterson to represent you on the misdemeanor case.
Darren's a busy guy.
Okay, it's Jim Watts or James Watts?
Same thing.
Okay.
Should I call him Jim
They
or
should have
James?
his contact information there at the jail if you don't already have it.
Okay.
So you've got court dates in both cases. Well, maybe I didn't set a court date for you on the misdemeanor case. That'll be October 19th at 8 o'clock in the morning.
And there's no way for the September court date to be set any sooner?
That would have to go through Judge Ricky's office.
Okay, and I'm sorry, what was the October court date? I
That's for
apologize.
the misdemeanor case, October 19th at 8 o'clock in the morning.
Okay, we're going to mute them for just a second. We've got a call.
Okay,
All right, Mr. Bob.
Hello? Hello?
Hi, good afternoon. Dwayne?
Yeah, what's up?
Hey there, my name's Tony, and I was calling you from the expired accountants department here. The reason for the call, records are indicating here you've got some travel credits on file with us. It looks like you purchased a vacation package a while back, but you never did book trips or travel, right?
I buy a lot of things I forget. When did I buy it?
Oh, it's been over 3 years, so we're the expired accounts department. So the package was up for expiration. That's how it came over to us. However, they are offering you in the package for a lifetime now. So instead of it expiring on you, they're going to open it up, make it good for a lifetime for you. So whether it takes you 6 months, even 10 years to travel on it, you'd be able to do so. So you know what, Dwayne? Let me pull up your account. You want to grab a pen and a piece of paper? I could run it by you real quick. Only take 3 minutes.
Yeah, give me a minute. I have a really bad memory.
Okay.
You said pen and paper? 1 second.
Yeah, grab a pen and paper.
Okay.
All right. So first off, you can write down my name. So you know who you're speaking with. It is Tony, Tony.
Are you the person I bought it from?
No, we're the fulfillment department here. We handle all expired accounts. So when packages go up for expiration, they do come over to us. We actually do the booking right here on site. So we're not a third-party marketing firm like the rest of them. So when packages come over to us, we do try to fulfill them. And like I said, we actually book the trips right here on site. So first off, go ahead and write down lifetime. Like I said, whether it takes you 6 months, even 10 years to travel, you'd be able to do so.
Is that the brand or is it the lifetime brand?
No, the package is good for a lifetime.
Oh, okay.
So you got a bunch of trips here. So also you could write down transferable because you got several trips here, like I said. So if you wanted to gift out any part of this to any loved one or any friend, you can absolutely do so.
Okay,
free of charge.
I got a sliver under my finger. It's I write really slowly because it's like swollen. I've got a hangnail. Just 1 second.
That's okay.
You said transferable?
Transferable. So you could give any of this out to anybody as long as they're over the age of 25.
Okay.
Okay. So it does look like here they're starting you off. You have a 4-day, 3-night stay in Las Vegas, Nevada. You have your choice of staying on or off the strip.
Can you do that like a wintertime one? Because I do not do warm places at all.
Yeah, you can travel any time of year you like. There's no blackout dates.
So winter.
And then,
does it snow there, or is it? I have never been.
Does it snow in Vegas?
Yeah.
No, it doesn't snow, but it does get really cold. So
Can I
yeah, you
change
have
it
the
for one that does where there is snow.
Yeah. So let me finish. So you have this trip in Vegas. You also have a 4-day, 3-night stay in Orlando. Well, it does get pretty hot in Orlando as well. Now in Orlando, you'd be right near all the major theme parks and attractions. Now, however, we do have what's called our VIP destinations. I got to see if I can get that in the package for you. With that, that'll give you about 12 other destinations to choose from. So you got.
On my bucket list, I want to do a snow angel. I've never done one, and I'd love to. If there's a spot where it snows, do you have? I mean, Orlando's in Florida, right?
Yeah, Orlando's in Florida. However, we got Daytona. There's Miami. There's Lake Havasu. There's Gatlinburg, Tennessee. There's Pigeon Forge, Tennessee.
Okay, you're going really fast. Where's Daytona? What state is that in?
That's in Florida.
Oh man. Do you have anything like further north?
You got Lake Havasu. You got Williamsburg, Virginia. You got Myrtle Beach. You got Hilton Head, South Carolina. You got Gatlinburg, Tennessee. You got Pigeon Forge, Tennessee as well.
I
You
don't
got
mean
the
to be.
Poconos.
I don't mean to be weird. I got heat stroke really badly as a kid. I can't go where it's hot. Do you have anything that's like a cold weather vacation, like an Arctic or Antarctic, or I mean not that far, but Alaska or oh man, I'm never gonna get this Alaska cruise out of them. I'm trying though. I just wasn't ready to write anything. I did get a pen out, but all right. Okay, we're supposed to be going back to court here in just a second. We'll be there. Oh, well, let's go to this one for a second.
Appointed for you. However, you may be responsible
Wednesday's
for
in
some
court
of
today.
those costs depending on what happens on your case. Do you understand that?
Absolutely.
Okay. Do you still want to represent yourself, or do you wish to have the court consider appointing an attorney for you?
If I could get an appointed attorney, I was just told I make too much in the beginning of all this to get one.
Okay.
How much do you make?
What, are you working?
I'm working full time, yeah.
Where do you work?
OF? I mean,
Nordstrom Rack and Bradley Fair.
Shouldn't have said that.
Do you get paid by the hour?
Yeah,
And what do you make each hour?
18.
Okay, well, you probably would not have qualified for court-appointed counsel,
Yeah.
but you're going to have to stay in jail until next Friday on this no bond hold. All right, anything else, Mr. Baca?
Nothing further from the state, Your Honor.
All right, any questions, Ms. Young?
So I have no bond out of here?
That's correct. Judge Webster's the judge on your case, and she ordered a no bond hold.
You must have skipped something, like court.
I'm sorry, sir. Okay.
It's important to show up to court, Miss Young.
I know. I just got the dates mixed up.
All right. Well, you've got a court date coming up.
You're not going to miss that
August
one.
7th at 1:30. We'll be in recess.
It's important to show up to court. Yeah, that hits hard. That's a very painful lesson to learn. I'm not saying she's not telling the truth, but yeah. How did they get their orange jumpsuits to be so
Christopher
vibrant?
Troyer.
Do you think they use Tide?
Yes.
All right. We're on the record in State of Kansas versus Christopher John Troyer, 25 CR 370. The state appears by Joseph Baca. Mr. Troyer appears in custody from the Butler County Jail. Looks like he failed to appear in front of Judge Rickey on March 30th of this year.
Yes, Your Honor.
Judge Rickey did issue a bench warrant bond forfeiture, ordered that you be held without bond. I'm going to put this back in front of him. And it looks like you are awaiting sentencing.
Yeah.
Okay, I'm going to put.
I had a piece of paper that said that it was rescheduled for August 11th.
Okay, well, you'll need to take that up,
Okay, we
Judge
need to go
Rickey.
back. We need to go back with Judge Stevens because he just sat down on his bench. He's getting logged in. Saying, where's everybody? Go get him. The bailiff and court staff have been laughing and joking before the judge got in here. No audio. There's been no hot mics yet this afternoon, post lunch. So
All right, we're ready to proceed in this cause number 23, CR 727, the state of Texas versus Raymond Pickles. I'm asking bailiffs to bring the defendant in, and then we'll bring the jury in. Make sure the jury doesn't come in yet.
Hey.
Yeah, we don't want to see he's being escorted.
He's already shown them the shock collar ankle thing, which I honestly, there's a chance they use that today. There's a chance he gets the zap, especially if it comes to. I mean, he's thought about what he wants to say over this little break. He's regrouped his poop, and he's ready to stand and deliver when it comes to what he wants to say.
My mother said there would be days like this.
My mom had no idea.
Mama told me not to come. Yeah.
She's that clairvoyant. We need to talk to her about the lottery number.
Okay, we've got that one.
Man, it is so hot out there.
That would have been a good one too. Just missed it.
You know what they did? They turned on the spindle top spray.
Oh.
I gave Lamar, Marcy and I gave Lamar the gift of the original, one of the original photographs of the spindle top blow on the day it happened. It's it's one that's has only been published one time 125 years ago. And it was in an auction, and Marcy and I bought it and we gave it to Lamar. It's great to have it here in Southeast Texas. They're going to put it at the museum, the Spindletop Museum.
What is he talking about?
You know why they call it Spindletop?
No. Tell me.
Why?
Because the trees around where the oil field where they were drilling in, the trees were above on hills, and the trees looked like spindles in their leaves, and they called it spindle at the top, and it turned into spindle top, and that's the way that geyser ended up being named that way.
It's a geyser, spindle top spray. He bought a
I thought
geyser.
it was like a machinery part or something.
He bought a geyser.
Mr. Peebles, just sit up here. We'll put you right back where you were. We'll pick up where we left off.
Hopefully not right where we left off, because we were talking about poop.
All right, stay ready.
Yes, sir.
Defense ready.
That was the picture from earlier. The
Bring
oil
the
well.
jury in.
The oil well hitting the hitting the oil and having it spray everywhere. That picture he's gifting to museum. They're going to display in a museum. That's awesome. That's really cool. That's what he showed earlier. I like it better when we talk about food. It was an oil well picture from back in the day. A gusher. Don't glare at us like Judge. When you narrow your eyes like that, it makes us think we did something wrong, and you're about to let us know. Defendant has struck the thinker pose. Very different from the stinker pose. But
And the jury is seated in the courtroom. All parties are present. When we rested last, the defense was making his statement in his case in chief. You may pick up, sir.
So, never caused no problems. Isolate, not this time in isolation, but time where 3 years ago when they charged me with this charge, right? Never caused no problems in isolation, so all the COs would let me go to the day room in the cage on the run. The video, the pictures that y'all seen, where they took me and put me in a wrap, that's the day room on the run. They can take the cuffs off you and let you work on the computer, talk on the phone, watch the TV, take a shower, right? In isolation, your movement is very limited and whatnot. But I would refuse to go back to the run because there was too many people playing with weights, too many officers that on a regular basis that like to take my paperwork. It happened actually 2 times. So after the second time, I wouldn't go back to the run. I just go to the run to go to the day room. So when I passed by that cell the night before Ford came to have fun with me, when I passed by that cell, I seen dude, it was streaks of his waist smeared on the window. And he even had it on his body. When I came back, he was still in there. After my hour day room, they put me in that back in my cell, isolation cell 6. A couple of hours later, he got moved to infirmary isolation. Nobody ever came from that cell. I was up practically all night. Nobody ever came from that cell. That morning, when Ford came woke me up, it was around 7 or 8 o'clock. I'm letting them know that I just need somebody to clean the cell out because they moved that dude last night. I need somebody to clean the cell out. All he kept saying is it's already been cleaned. It was cleaned last night. I say, no, it wasn't. No, it wasn't. Can you please have somebody clean it up? No, it wasn't. He insisted that it was cleaned last night. He telling the other officers. Even Stevens, I'm telling Stevens, bro, can you please just go clean the cell out, man? He said it was already cleaned out, man. We just need you to go in there. So when I told Darby just actually finally decided to go down there himself and clean and look, check. When he got back, he said, yeah, I see what you're talking about, man. But listen, once you get in there, I'm gonna make sure you get some. I'm gonna give you chemicals. Once you get in there, we take stuff. I'm gonna make sure I give you chemicals and a mop and such. I say, nah. Last time he wouldn't let Levine give me that stuff. I don't trust him to do that. Just listen. When he walk out, just go down there, sleep down there, and throw it in the cell for me. Just throw it in the cell. He said, look, man, just come on, man, stop giving us a hard time, man. No. Why is y'all thinking that is okay? It's not okay. Now, all 3 of those officers sat in this chair and told y'all the same. They all told y'all that I was complaining about this cell being nasty and wanted it to clean up at that very moment, which means everybody had knowledge of my contentions about moving in that cell without it being clean, right? So that was a simple fix. Throw the chemicals in there in the mop, in a rag or something, and I'll do it myself. He wouldn't even let them do that. And they kept trying to make excuses for me to just chill and do what he's telling me. Now, if everybody had that knowledge, why is they only taking pictures of isolation cell 6? Okay, everybody know I'm in isolation cell 6. Why do you need pictures for isolation cell 6? Why are you not taking pictures of isolation cell 1? Why is everybody hiding the evidence of them trying to indirectly kill me and trying to make it seem like I'm some type of thrown off, chaotic person? I haven't done nothing to nobody in this jail for them to be doing it, which means somebody got to be sitting. I'm talking about one after another. Where did this come from? I ain't never had no problems with Tinker. Why he did that? Yesterday, when I got back to the jail from this court, I've been, like I said, this is my 4th trial. I came to hearings plenty of time. They ain't never searched me coming back from court. They'll search me going to court, but they never search me coming back from court because there's no need to. right? Like, yeah, when I get back from court, Lieutenant Davalos and Sergeant Hawkins made me strip out butt naked, squat and cough while the cameras was going. And they stood a distance so the camera could see my whole body. I'm asking them, what is this? Is this to make me, what? So somebody told y'all to record this so they can have some fun afterwards? Why y'all got y'all recorders on? Y'all ain't never made a person strip out while recording. And why is it taking a rank to do this? The officer, I ain't never been strip searched by no ranking officer. It's always a regular CO that'll strip search me. Why is it 2 ranking officers with their cameras on, standing just 3 feet away from me, enough for it to see my body? They got their heads turned like they don't want to see me. Somebody had to send them to do that. Right after I left court, yesterday, humiliating me. For what? Because Ford told him to? Because Ford admitted that I didn't stab him? Because they know the jury gonna find me guilty regardless, no matter what I say, and it won't add up?
Anything else?
Yes.
Please get to the end, sir. Thank you. And again, stay within the 4 corners of the allegations. I've said that. That's what we're here for. Whether or not you have committed this crime of the first degree. Sir, let me complete my sentence, please. She's counted up how many times you have interrupted the court during this hearing, and it's numerous times. Let me speak, and you have a fair opportunity to be heard. Stay within the 4 corners. That's what's relevant.
All right.
4 corners of the accusation. Thank you for following the rule. Go ahead.
So,
The judge is frustrated that the prosecution's not objecting when he goes off the rails. Steps in sua sponte.
wow.
Big shout out to Sweetwater, who just did a 20% price drop on my favorite headphones. I'm getting some more. I heard Stubby very quietly.
All right. I'm fine right now. But well, the habeas corpus to this case, November 15th, sent the habeas corpus to the court, November 15th. It was filed in December or whatnot.
There's a whatnot?
The habeas corpus was explaining how Lieutenant Ford's statement admitted that I didn't stab him. And I also explained why I was combative, which made that charge completely illegal, right? In America, right? In this country, when an indictment isn't in the 4 corners of the allegation, right?
He's using 4 corners.
There we go. there's grounds for dismissal and to produce the body. That was like 10 months ago when I filed this, right? They wouldn't even give me a hearing for it, right? The habeas corpus is that thing that Donald Trump wants so much to abolish because of situations like this.
No, I'm sorry, sir. You're misleading the jury. Habeas corpus, he is getting his time at trial. He wants his time at trial under the Constitution. That is his habeas corpus hearing right here, essentially, but with you and the jury. It was indicted. I don't make the decision on indictments. He didn't come to the judge for the determination of guilt or innocence. He has insisted on a jury trial, and with this being the 617th jury trial, we're trying as much as we can, as fast as we can, ladies and gentlemen. But under the law, this is what equivocates to a habeas corpus proceeding. This is the trial by jury. He has been insisting. He has it, and that is irrelevant. You can move forward. This is your time to be heard, sir. So I'm allowing that in spite of the difficulties here. Please proceed and move forward. Thank you.
Your Honor, I would like you to issue the writ of my habeas corpus, my pretrial habeas corpus for this charge.
Okay. That is denied because it is not presented in the correct way under law. That's why I've asked you, please work with an attorney. If they help you do it correctly. And when you insist on representing yourself, you have to follow the rules like all others. And the court is the person who makes the ruling like a basketball official on the court.
Article 1148, written issue not necessary. It shall not be necessary on the trial of any cause arising under the habeas corpus to make up a written issue, though it may be done by the applicant for the writ. He may accept to the sufficiency of or controvert the return or any part thereof or allege any new matter and avoid it.
Sir, I'm going to present the law that's necessary for the deliberations. A writ of habeas corpus does not substitute for a trial by jury, ladies and gentlemen. This is what he has asked for. He's getting the trial by jury. An application for a writ and a writ hearing is a separate, completely different sort of circumstances. This is what the Constitution allows, a trial by jury, and we've got him here as soon as we were able to get him in the queue with our trial backlog that we have in this county. But we can only try one at a time.
All persons is innocent until proven guilty.
No, sir, that's incorrect. The jury knows that.
My bad. All persons are innocent unless.
There you go. Good for me.
Right. So at my probation hearing, when you said based on the scientific.
No, sir, we're not getting into the probation hearing, sir. I'm sorry.
I sentenced you to 20 years.
All right. That you keep interrupting the court. You will be placed outside.
I was talking.
We're going to have right now the jury is going to be excused. This is a trial about the allegations of this indictment, and you have to stay within the allegations of the indictment, sir. We're not going to torque off on theories that are not relevant to this trial, sir.
Say twerk off.
And also, I have instructed you about interrupting the court so I can make a ruling with the court reporter. When you keep interrupting, I am unable to do my job. I've asked you not to do that.
In all
You
fairness,
keep
Your Honor,
continuing
you
to do
interrupted
that.
him in that one. He was talking already and you interrupted.
I was talking to you.
You were speaking about something that had nothing to do with this trial, sir. The next time you interrupt, you will be placed in a holding cell. We will have the trial for you to listen to. That's the way the rules say it happens when you keep interfering with the rules of decorum. Do you understand what will happen? Please follow those rules, Mr. Peoples. I want you to get what you want said, but if you keep interrupting and not following the rules, I don't have any choice but to change the circumstances. And you are the only one in this room who keeps not following the rules. Please follow the rules, and you have a chance to be heard and stay relevant to the allegations in this indictment. Do you understand, sir? We're in short recess.
I'd like to continue, Your Honor. I'd like to request to continue.
No, that's denied. We're going to complete this trial.
Requests a continuance. We're taking a short recess. But don't ask me how to spell that.
You know what? No.
Judge mutes us. Doesn't mute us. Thinks better of it.
Court is going to make some findings here that the defendant is intentionally prolonging these proceedings by refusing to follow the instructions of the court, by bringing forth statements and thoughts from matters that are irrelevant to the four corners of this indictment. He has been instructed numerous times to follow the rules. He continues to disobey the rules. He continues most often to interrupt the court when the court is making its rulings and findings on the record, which prevents this court from doing its job. And I've warned the defendant, if he keeps that up, we have no choice but to put him in a different room where he can listen and watch the proceedings without interrupting them. We'll see what happens. This has been consistent in this trial and railing on about matters that have nothing to do with the four corners of the charge is obviously an attempt to prevent this trial from ever ending.
Yeah, I haven't.
And the court has a duty to move forward on a trial in an expedient way that's fair to all. And he's preventing that from occurring. All right, let's bring him out.
Okay, he has not heard those rulings, though.
I got this.
Those findings.
And the picture of the first one, just Dollinger. I did that. I know for the last 30 minutes, I got more done in 30 minutes than I have in there all day.
All right, let's get the jury in, please. Thanks, you, Kendall.
Let's see this hearing. You got bulletins.
I don't think he heard on Zoom.
What are you with it? Always fight for what you got.
Sir, do not speak except to answer the questions while the jury is here. Don't be making statements in front of the jury, sir, that aren't part of the question and answers.
He was nodding. How you doing? How's it going? To the jury as they're coming in. What's up? Hey, bud. You and me? We speak in the same. You smell what I'm stepping in? Oh my goodness. We're gonna get a "don't tase me, bro" moment out of this one, I'm pretty sure.
Record shall show the jury is seated. Thank you, ladies and gentlemen, for your attention and your patience. All right. Mr. Peoples, you may go forward. Be mindful of staying within the relevancy of the four corners of this indictment as it is alleged. Thank you.
You've got one more chance.
You may
sir.
proceed.
This is your last chance, I think.
Lieutenant Ford, I was cussing him out one day, and he said to me, "You must love living in prison." I said, "No, I'd rather die on my feet than to live on my back." He said, "That's so chic." He tell me like that. That statement is so cliche. Okay. That's because you used to doing people like me the way you do them. Something like that means nothing. I told him it means a lot to my kids, though. And I'm gonna make sure my kids understand to always fight for what you love. That's what I told him. I said, man, listen, I would not be a good role model if I gave up on my kids. So, you know what he had to start doing? He started having people tamper with my mail, blocking their access to the courts. Once they bid for me, I'll be out at June 25th, 25. I had wrote a complaint on the federal judge about allowing Judge Stevens to keep me in prison.
Here we go. This is it.
In violation of the habeas corpus procedure. 3 weeks later, he had me bench warrant out here. 12 months ago. 3 weeks later, he had me bench warrant out here. Threw me directly into an isolation cell, blocked my communication about 5 months. And the whole time, Lieutenant Ford would cut my water on periodically. And I would have to argue and trip out about it just to get it cut back on. And that complaint was on a judge for him refusing to rule on my habeas corpus.
Wait, hold on. So the jury is clear. Are you saying that I ordered sanctions against you in the jail? Is that what you're telling this jury? Is that what you're telling this jury, sir? Under oath.
I'm telling the jury that Lieutenant Ford is able to be doing the stuff that he's doing to me the past 12 months because I wrote a complaint on a federal judge for refusing to rule on my habeas corpus, which was complaining on you. And 2 days later, he ruled on it, but I was bench warrant out here. He ruled on it July 16, 2025. I was bench warrant out here July 18, 2025. But June is when I wrote that complaint that sent it off. Which means it took about a week to get to the court, which means it only took 2 weeks for me to get bench warrant out here. Through an isolation cell after he denied my relief.
The federal, you're telling the jury that the federal judge denied the relief you were requesting, correct?
Right. And
okay.
He bench warrant me out here.
All right.
I mean,
move forward.
That's the only way I can be bench warrant out here. How did you know he denied my relief? Just 2 days before he bench warrant me out here. And when I get out here, y'all put me directly in the isolation center. TDC. I wasn't in the isolation center. I had been in TDC for like almost 2 years. But as soon as I filed a lawsuit a few months before and a complaint a few weeks before, I get benchmarked out here and harassed at an extreme rate for 12 months by the two people and his co-conspirators. I sent off an appeal for that habeas corpus. August 8th, August 6th, it was filed August 14th. In that appeal was my certificate of appealability. I had Sergeant Knott walk me to the lieutenant's office to call the court because I couldn't use my own phone because they were blocking. So he walked me to the lieutenant's office. Mind you, they will only do that if you don't cause, if you're not a problem. So he walked me to the lieutenant's office and he let me call the court. I called the court and I asked them, did they get my notice of appeal and my certificate of appealability along with my emergency? They say no, all we got is the notice of appeal. It was under review for jurisdiction. They know, which means all of that went in the same letter. It was in the same envelope. So for my notice of appeal to only be there, and then my certificate was identified on that notice of appeal. But my notice of appeal not filed. Not notice of appeal. My certificate of appealability was identified on that notice of appeal. So for my certificate of appealability to not make it, will only have to mean somebody in the jail took it out of my envelope before it got there, or the clerk had it simply is not bothered and throw it away.
Now he's throwing the clerk under the bus.
Sergeant Knott camera was going at the time when I called, and my anxiety went crazy. After that, they were not. I had to send off another certificate of appealability. And I started giving my envelope directly to the COs. For them to give it directly to the mail agent to get off the unit. And write their name and the time and the date on the envelope. Just to make sure it got off the facility. When I sent my other certificate of appealability, they end up denying it. Turned around, I sent the emergency motion for reconsideration. I called court on the 9th of January. My certificate was denied on the 30th of December, which makes the deadline would have been the 14th of January. I called on the 9th to make sure they made it. And they said, I called on the 9th to make sure whether or not they ruled on my certificate. They said my certificate was denied on the 30th of December. So I sent off my motion for reconsideration on the 12th. When you're in prison or any type of institution, the day you file a motion, the day you put your motion in a penal institution facility is considered filed. But they told me I was on time because they ain't getting to the tune. Throughout this country, in every state, the rule is the day the inmate places his motion in a penal institution mailing system, it is considered filed in the court. But they refuse to follow with the panel. For them to do that, a judge having allowed them to do it. So they wouldn't address the issue of this charge and all the other charges. So after that, I filed habeas corpus with the Supreme Court. The Supreme Court will not file your habeas corpus if you don't do it right and if it is not in good faith. But yet they filed it. They docketed it. And one of the justices denied it. I didn't know they went this far. I thought I was safe in the Supreme Court. But the fact that I sent off an emergency petition for rehearing June 9th, and I'm sitting in this courtroom witnessing what just took place the past 2 days, especially at the jury selection, I know that it must be people in the Supreme Court allowing me to do this, because they will not let me go to this trial no other way. But then when I do get to the trial, they violating every right in the Constitution. Every single right, especially the Sixth Amendment. And I want everybody to know this. Even if you give me life in prison, that will not provoke me to hurt myself or nobody else. I'm gonna make sure my kids understand resilience, perseverance, integrity, dignity, honor, decor.
Decor. Here we go.
Very important. Never let nobody take that away from you.
Now he's talking to his kids.
I'm done.
I'm done. You can't.
Hold on.
Cross-examine.
He has a right under the Constitution for cross-examination, sir. Did you want to ask any questions?
I don't need to talk to him.
Okay, you're excused.
Defense, do you have any more witnesses? Got to have good decor.
All right, anything else, Mr. Peebles? Do you rest? I take it from your silence, you're resting your case. Anything redirect from the state?
No, Your Honor.
All right. Ladies and gentlemen, we're going to take a short break here. The court is going to finalize the jury instructions that we've been working on, and we can't finalize them until the parties have rested. And then we'll bring you in and go over the charge, and then
closing arguments.
Parties can make their final arguments to you. You'll go into the Thank you. That's our plan. Thank you. Everyone else remains seated while the jury exits.
He didn't make a judgment of acquittal argument.
Here.
I don't think he would have won that either, but he was overcome with his own hero-ness. When the court ruled against him, they basically said, look, you're just mad it didn't go your way, but this process looks fair.
All right, the jury is exiting. The court has provided the parties with a jury instructions. We're going to go over these. Mr. Peebles, make sure that these are in order. Members of the jury introduction. The court will note that the defendant has pushed aside the jury instructions and is refusing to review them.
He's demonstrated decor.
The court will also note that when I asked the defendant if he had completed his presentation of his case, he refused to answer. Then second is definitions page, then assault, aggravated assault with deadly weapon against a public servant, bodily injury, serious bodily injury, public servant definition, correctional facility, deadly weapon, intentionally, knowingly, recklessly, jury charge, general instructions, 3 pages, 2 verdict forms. We, the jury, find the defendant guilty. We, the jury, find the defendant not guilty. The state, any.
Judge, there's an issue back when you got the definition of assault, and the next one says assault on a public servant. That's not the correct definition of assault on a public servant. Aggravated assault on a public servant. It's just an aggravated assault.
We've got a poll going right now. I'm sorry.
Well, to B is section 20. It's under section 22.02 called aggravated assault.
No, it's under.
That's the way
it is, but it's
that's the way it was indicted, folks.
It's not. No, but there's more to it than to be a public servant, not an aggravated assault. See, you got it.
No, I know it's called, but it's called aggravated assault. It's under section 22.02, which is aggravated assault. It's a form of aggravated assault.
I understand that, Judge, but you put aggravated assault of a public servant, and nowhere in that definition does it have public servant of a public servant in the performance of his duty, which is what it's supposed to have.
How was it indicted? That might be important.
2.
Is this 2A or let's see, 2A, 2B, 2B.
B, 2B.
Yes.
JMR, why does the poll have no? The defendant proved he attacked the CO. He did. Proved it. I'm sorry. I let that one slip.
Oh, yeah.
That one just squeaked through. Please don't read the poll too carefully, though. You can just hurriedly vote. It's fine. You like the not proven option? So we now get to go to closing arguments, which, believe it or not, the defendant has even more leeway than he had when he was on the stand. With the exception of if he strays into facts not in evidence too far, I think the judge will sustain that objection. But he gets to really craft his story there. It's not proven. Objection he just gave his closing. He's teaching us all about decor. I want to see the defendant's decor during this. And I mean, honestly, you look at this, either this defendant is the lone man, the hero in this story, or he's definitely the villain. I don't see any other options than those two. Either the defendant is right when he says most of the guards, a lot of the inmates, the court clerk, the judge, and even the Supreme Court are in on this conspiracy against me. Or
all right. They're right. Assault, aggravated assault with deadly weapon against a public servant. And I think this is
How is it indicted?
The right definition here. A person commits the offense of aggravated assault. If he commits assault against a person the actor knows is a public servant lawfully discharging an official duty.
Lawfully discharging an official duty. So he might be able to argue against that, saying they were harassing me. That wasn't an official duty. They were just torturing me in the way they can as guards. That was not something official, but it's not a strong argument. I mean, the guy's in uniform inside a prison on shift. He did say duty.
Okay. It's a person commits the offense of aggravated assault if he commits assault against a person the actor knows is a public servant while lawfully discharging an official duty. All right. What other changes?
No other changes.
Anything, Mr. Peebles, you want to change on these instructions?
I wish I could change the word.
To what?
I wish I could change the world. What his statement is. All right. Please make this change. Otherwise, any other objections by the parties?
No, Your Honor.
All right. We'll make this change, bring the jury back and read the charge, and then the parties can make the final arguments.
Yeah, the judge is not excited about these closing arguments. The defendant in his narrative testimony, I counted at least 4 times, berated the jury themselves, claiming that they would convict him no matter what, that they were biased, that they have close connections with multiple individuals that are involved in this case. Not the way to endear oneself to the hearts of the jurors, who are now missing out on the second day of work for this. Or is it third day? I think it's third day. Seems like fourth. Yeah, you're not my peers. We got that part. We can handle this with decor. Okay, so Joe Sherlock, you say take the animal doo-doo, and then when I hover over it, you can only see it when I do this. Look, see what it says right here. Take the animal doo-doo. When I hover over it, it says yabba dabba doo-doo. What's with that? It gets translated for some reason. Like Google thinks that you're speaking in another language. I think law isn't a great career choice for him. He's going to need new books for sure if he's going to do this. His other ones got taken by the guard and possibly regifted to someone else or thrown out because they stank. Stink, stink, stunk. Don't think the defendant has all his marbles. He's doing better than most pro se defendants. Unfortunately, most pro se defendants, the court process is not long enough to learn the legal system. So if you're learning on your own case, you'll lose. If you can somehow watch entirety of other cases, you stand a chance. Yeah. Red Pen, I don't know why it's translating like that. I wish I could turn that off, because I'm pretty sure you didn't type eat the beast doo-doo. Why did you throw Trump in here as well? Trump's trying to do away with habeas corpus. There you go. I'm not trying to start a fight or anything. Just that was, of all the things I expected to hear in a trial about poop, that was not one of them. I did not type that. Red, let me just for the record, let's just go back here and see what Red Pen right above this. We was Flintstones saying, and Red Pen says, "Eat the beast doo doo," or "Yabba dabba doo doo." I'm not sure. One of those two things. I'm gonna miss this trial. I love you guys. I'm not gonna miss. This feels like the ending of. We're up with Daryl Brooks again. Like, I feel like we've been together that long in this trial. But this was a fun one. This was fun.
Remember in the beginning when we started 110 years ago?
Here comes the jury. They're coming in. Take a seat. Pop a squat, if you will.
In front of the Walmart.
Did Judge just mute us?
Record shall now show that all parties are present and the jury is present. Anything to bring up further by the party, state?
No, Your Honor.
And Mr. Pickles on defense. Anything further?
He's praying.
There's no answer. Earlier I asked, and Mr. Pickles said, "I wish I could change the world." I'm going to move forward here. And at this time, the court will read to you the jury charge of the court, which contains the law applicable to this case. Ladies and gentlemen, in continuing to discharge your responsibilities as jurors, you must continue to observe all the instructions previously given to you. These instructions are given to you because your conduct is subject to review, the same as that of the witnesses, parties, attorneys, and myself. Please listen carefully, as I know you will, when I read this charge to you. It will be left with you to refer to as necessary during your deliberations, ladies and gentlemen.
Necessary.
Members of the jury, the defendant stands charged by indictment with the offense of aggravated assault against a public servant alleged to have been committed in Jefferson County, Texas, on or about June 6, 2023. The defendant has entered a plea of not guilty to this indictment.
Voice.
Our law requires that I submit the following charge to you in this case. This charge contains all of the law necessary to enable you to reach a verdict. If any evidence was presented to raise an issue, the law on that issue must be provided. Definitions. So that you can better understand some of the words and terms used in the charge, the law provides the following definitions. Assault. A person commits the offense of assault if he intentionally or knowingly or recklessly causes bodily injury to another. Aggravated assault with deadly weapon against a public servant. A person commits the offense of aggravated assault if he commits assault against a person the actor knows is a public servant while lawfully discharging an official duty. Bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Public servant. Public servant means a person elected, selected, appointed, employed, or otherwise designated as an officer, employee, or agent of the government. even if he has not yet qualified for office or assumed his or her duties. Correctional facility. Correctional facility means a place designated by law for the confinement of a person arrested for, charged with, or convicted of a criminal offense. The term includes a confinement facility operated by the Texas Department of Criminal Justice. Deadly weapon. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Intentionally. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. Knowingly. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Recklessly. A person acts recklessly or is reckless with respect to a result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the defendant's standpoint. Charge. Now, if you believe from the evidence beyond a reasonable doubt that in Jefferson County, Texas, on or about June 6, 2023, the defendant Raymond Pickles did then and there intentionally, knowingly, or recklessly cause bodily injury to Charles Ford by striking Charles Ford about the head or body with pens, and the defendant did then and there use or exhibit a deadly weapon, namely pens, that in the manner of its use or intended use is capable of causing serious bodily injury or death during the commission of said assault. And the defendant did then and there know that the said Charles Ford was a public servant, namely a Jefferson County Corrections officer in the lawful discharge of an official duty, to wit, transporting said defendant with the correctional facility. You shall find the defendant guilty of the offense of aggravated assault against public servant. Stand by.
Judge found a typo.
Unless you so find, or if you have a reasonable doubt thereof, you shall find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt, after careful and impartial consideration of all the evidence in the case.
I like how he says
The
reasonable.
prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. You have a right to consider all of the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are in this case. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. And it is improper for any juror to discuss or consider anything which they know or have learned outside of the testimony presented to you and the law contained in this charge. If a juror should discover that they have any outside information, they must not mention this information to any other juror, nor consider it themselves in arriving at a verdict. Questions and comments of the attorneys or parties, if they represent themselves, do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys or the defendant representing himself that is inconsistent with the law contained in this charge. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question about the law develops during your deliberation, it must be reduced to writing and signed by your foreperson, and then be given to the bailiff. The question will then be answered by the court as soon as possible, to the extent allowed by the law. Any physical exhibits which have been admitted into evidence will be furnished to you by the bailiff upon your request. After the attorneys and the defendant present their arguments to you, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during your evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision or decisions, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case in accordance with the law and the evidence. There are two options you have. One, we the jury find the defendant guilty of the offense of aggravated assault against public servant as charged in the indictment. Place for the foreperson to sign. Your other option, we the jury find the defendant not guilty of the offense of aggravated assault against public servant as charged in the indictment. A place for the foreperson to sign. Of course, only one jury form can be signed. Under the rules, the state of Texas may open and close final arguments. What says the state?
State of waive its right to open, reserve its right to close, Your Honor.
Okay. The state has waived its opening. Mr. Pickles, you can move forward and give your final argument now.
He chooses to do so. Just ended the poll. Did the state prove that the seal was attacked? Yes, 78%. Testimony was pinched off too soon, 17%. And no, 5%. That's 148 votes. Here we go. This, I think, is when the whatnot counter is going to go up.
During the video, during examination of the video yesterday, you all seen and witnessed that when I exited the cell, I never swung or struck anybody with those pins. Even more so, what's the name? Sergeant Anderson blatantly said I struck Lieutenant Ford with the pins after Lieutenant Ford admitted that his injury came from my fingernail. You also heard the testimony of everybody that say they don't remember seeing me strike Lieutenant Ford at all with the pins. 5 people was there. Only one person said that. 4 people is not gonna mistakenly miss something so explicit. Especially the way it was strapped to my hand. Clearly, I was doing what I was doing to deter his actions and discourage the constant harassment. Clearly, that didn't work.
Clearly.
So, being that didn't work, I obviously had no intentions on stabbing him. When I grabbed his face, I could have gouged out his eyeballs.
I didn't do that.
This is not a good argument.
Clearly, my intentions wasn't malicious. I just simply wanted the cell cleaned, which by law, that's cruel and unusual punishment to force somebody amongst something like that. But yet, everybody, exhibit, one, two, no, I forgot which one it was. But after I showed, what's his name, Detective Gardner, his report, he said he did write this or whatnot. And one of them, one of the papers is being, he stated in his report, Lieutenant Ford indicated in his report that Pickles exited the cell holding a pen in each, and holding the ink pen in a manner to use as a deadly weapon, but he believed the visible injuries he received come from Pickles' fingernail. His aggression was focused on Lieutenant Ford as he used the ink pens to cause several lacerations on Lieutenant Ford's face, neck, and upper chest. Several of the wounds were close to Lieutenant Ford's right eye and could have resulted in more serious bodily injury. So, regardless of how they manipulate the law on the instructions, the indictment is clearly stating that I stabbed him. His probable cause affidavit is clearly stating that I stabbed him. His report explicitly demonstrates that I stabbed him.
He's not doing terribly yet.
The indictment expressed that I threatened with imminent bodily injury, which would be force of a violent nature, right? Which would be assault, not aggravated assault. Aggravated makes it becomes aggravated when you use a weapon. Simple as that. Or cause serious bodily injury. One of the two. Use, not just exhibit a weapon, not just hold a weapon. When you exhibiting that weapon, you have to actually use it. Which means if you have a knife in your hand and you cut somebody, that's using it. If you have a gun in your hand and you shoot somebody, that's exhibiting it while causing serious bodily injury if that bullet hits them. Exhibiting it is merely a description of a remote injury. That's it. A threat to cause death or serious bodily injury by the production of a weapon or otherwise, as long as the actor purpose is limited to creating the apprehension that he will use force if necessary, does not constitute deadly force, which would be aggravated assault. Penal Code 9.04, Texas Penal Code 9.04 is what that
Sorry,
was.
I'm going to have to object. He's stating law that's not in the charge and is not before the jury.
The objection is sustained. Ladies and gentlemen, you can only consider what is within the jury charge and the law that the court has given to you. That is what the law states. It's in the judge's domain, the law to be given to you based upon the law. The parties are not allowed to supplement the law during final arguments, or to change indictments, or to change the laws. So your objection is sustained. Move forward, sir. Thank you.
A person commits an offense if he recklessly engaged in conduct that places another in imminent danger of serious bodily injury.
He kept reading.
The production, reckless and danger are presumed if the actor knowingly pointed a firearm in the direction of another or not, whether the actor know or not. That's what I have 20 years for.
I'm sorry. Once again, if people speak over each other, when an objection is made, Mr. People, you have to stop. You will have an opportunity to complete what you need to say for the record. The objection is sustained. Did you want to add anything else, sir?
Yes.
Okay.
So I want you guys to be aware that, so the day that the judge violated my probation, he gave me 20 years for the aggravated sexual assaults or whatnot, and then I went to trial afterwards and found, and it was found not guilty.
Hold on. Yeah,
I want you to understand that that was double jeopardy.
Hold on, sir. Hold on, sir. So the jury understands this court doesn't violate anybody's. I'm not violating anybody's probation. If someone is on probation, a motion to revoke probation is filed by the executive branch of government. It's not a jury trial. A motion to revoke probation gets heard strictly, exclusively by the judge, and the judge makes its determination based upon whether it's a preponderance of the evidence standard or beyond a reasonable doubt based upon the circumstances. But just so that you understand, so that you're not confused, this court doesn't violate anyone. And in the way that term is used properly in English. But if someone is on probation and violates probation and there's a hearing and the court finds that enough hearing supports the allegation of violation, then the court can grant the motion to revoke probation, then find the defendant guilty, and then the court has the authority to set a sentence based upon additional information that the court may receive for sentencing. That is the way that works. But once again, just so that you don't, so that you're not misunderstanding, this court doesn't violate a human being. I don't violate people. That's misuse, and I don't want you to misunderstand. But a person on probation, if they violate the terms of probation, not me, but if a defendant does, by proof, then the court can revoke probation and sentence a defendant. That's the way that works in motions and revocations of probation. This is not a revocation of probation here. This is an indictment separately alleging what you've heard throughout this case and what was read to you and what the court instructed you on under its instructions. All right, Mr. Peoples, you may go forward.
And yes, the judge is right. A court may violate a person if they're on probation or whatnot, if they have jurisdiction of that charge that they're violating that person on. But if they never had jurisdiction in the first place and that charge wasn't supposed to be in their court, they was never allowed to violate. It wasn't sanctioned. That act wasn't sanctioned by law at all. Actually, that's an understatement. They never had any legal right, period. No power to violate that probation. Correct, Judge? Is that correct? Is that right?
I believe the jury is making a determination on the indictment, sir.
Right.
The probation, any probations are not part of this case.
Correct, Judge?
Please strictly stand by what's been charged so that the jury is not confused. Thank you.
So
let's stay with the indictment and the proof for this indictment. Thank you, sir.
On this indictment, they plan on giving me 15 years to life because of my prior conviction,
I've got
which the
14
judge never
whatnots.
had authority to convict me on in the first place. Is that correct, Your
Honor? You're asking me a question, sir?
Yes.
No, move forward. This court has not been reversed in your cases. No, the decisions made in your cases have been final and approved and affirmed. Move forward with this argument. Thank you, sir.
I was just asking, was my interpretation right of the indictment that I have now?
we're talking about the indictment. There is a presumption of innocence, and I wrote the lead article in the state and law on the presumption. That's sacred. The presumption of his innocence exists unless the jury decides proof has been proven beyond a reasonable doubt otherwise. That's the rule of law. Go forward. Thank you.
With two of those charges being one being dismissed and the other one being found not guilty, I would be being held without indictment, right? The fact that I'm doing 20 years in prison for those violations, for those sexual assaults, would mean I will be getting held without indictment, seeing that two of them don't exist anymore, correct?
Your Honor, I'm going to object. If Mr. Pickles stick to arguing this case, he can do his appellate work with the appellate court, which he's already done.
All right. So
those rulings have already been sustained by appellate courts. Let's move forward on this case. Thank you.
All right. Witness against. Right. Anytime a witness themselves, the witness themselves, right? Not a prospective witness, but the witness themselves, the victim, admits to the contrary of the indictment. I mean, the Sixth Amendment would be getting violated when it says the accused shall be confronted by the witnesses against him. So if the court says that the jury is bound by the law, right? You know, for the love of God, right? By law, I'm not supposed to be convicted of this crime. Correct, Judge? Or did I
You
mean
don't
like
ask the court questions during final argument. You know that, sir.
Oh, I
make your final argument.
I just thought you were going to.
Thank you, sir.
Correct, Judge.
So
you got my back on this one, Judge?
The implements for an escape. The fact that the detective himself wrote that on one of his reports that the victim believes that he was scratched. And then on the other one, he admitting that I told him I had no intent, nor do he have any evidence of any intent to escape, right? It makes that those two factors also makes both of these indictments illegal. So, you know, that's pretty much all I got to say about this. And and also the law says whoever knowingly have knowledge, whatever officer knowingly have knowledge of the illegal confinement of the person that they have detained shall issue the writ without delay. Code of Criminal Procedures 11.15. And it is his duty to issue the writ without delay. That's 11.05. Penal Code, not Penal Code, Code of Criminal Procedures 2.03. The state, the prosecutor, the judge, and the attorney representing the defendant, with all attorneys, all court officers, shall conduct themselves to find to seek justice, not impair the ability of the accused to prove his innocence. 2.03 Code of Criminal Procedures. I'm done.
All right, state may close.
The jury. I wish we could
Got
see
for
you.
your patience this last few days. I hope you could appreciate the tightrope I've been walking, trying not to overdo that lawyer stuff and trying to help Mr. Pickles when I can. But there comes a time when we got to look and say, you know, all this stuff that he's been doing, he's already done in appellate courts and everything else, and they've all denied him, and so he's just he doesn't get his way, and so he keeps saying it over and over, just like he did with the lieutenant, hoping he'll get a tray. And I get tired of it because what he did that day on June 6th of 2023 was a violent act. And you cannot deny that, because if you deny it, then you have to say, I don't recognize the fact that he wrapped his hands in cloth, getting ready for battle with pins in them, and came out of that cell with his mattress out in front of him. Why did he wrap his hands with cloth and put pins in them? And why was he coming out of the cell with those if he wasn't intending to harm anyone? Second, you heard Lieutenant Ford say in his testimony that when Mr. Peoples reached for his face, lunged at him, which you've heard a couple of them say, lunged at him with his hands, he still had those pins in his hands and all he felt was pain. And yes, there's some scratches on there, but you also see that little sharp one. And that's where Arliss Anderson saw, standing right next to where Lieutenant Ford was struggling with this man, who all he had to do was say, I'll go down to the other cell. And he had a chance with Mr. Darby up here on the stand. You remember Mr. Darby walked all the way down to that cell and stuck his head in there, was in there for 30, 40 seconds looking around. And he did not come back and say, yeah, you're right. Because he could have asked him that while he was on the stand. And none of that ever happened. Darby said he went down there and looked, and the cell was fine. And all the officers went down there with him afterwards and said the cell was fine. So all that stuff he's doing is just a smoke screen, just like it was for that when he threw himself on the ground because he didn't get a tray. He doesn't get his way, and so he starts just doing anything he can to try to get his way. It's all about Mr. Peoples. Everybody's out to get Mr. Peoples. The appellate court's out to get Mr. Peoples. The judge is out to get Mr. Peoples. I'm out to get Mr. Peoples. I even have some influence with the Supreme Court of the United States and the Court of Criminal Appeals. I don't know where that comes from because I've never even been to the Supreme Court or the Court of Criminal Appeals, but that evidently I have influence there. I've wrongfully indicted him, wrongfully convicted him. He's doing 20 years in prison for something that he shouldn't have done, and he won't even accept responsibility for that, even though he knows he pled guilty to it. And we'll cover that later. But he can't just say things. He can't just come up here and say things, because everybody in that whole unit said that he came out with those pins and was flailing them around. They didn't see who he hit. A couple of them didn't see it, but Arliss Anderson saw it. Lieutenant Ford saw it coming at his face, and those pins were there. The wrapping was there. Everything's there that said happened. And you don't have to agree. You need to know that under this law, and you can look at the law. You do not have to agree on whether you think he did it intentionally or knowingly or recklessly. Some of you can think he did it intentionally. Some of you can think he did it knowingly, knowing he might cause injuries. And some of you can think he did it recklessly by the fact that he did it, because all that is an aggravated assault, and it's against a public servant who's doing a lawful duty. That cell was being decommissioned. You've heard them all say it. They have to follow certain standards. They were decommissioning that cell. They had to do some work on it to make it safe for them. And then you get back to, why do you have to do stuff on cells? Because, even introduced it in here, people get out of their cells to attempt to escape. This man did. He introduced it himself. He put his cell, plugged up the cell lock, and walked out and was wandering around. They caught him in a trustee uniform, walking around with a blanket where he could get out. All that's the stuff he was introduced. So y'all need to think about this. This man does not tell the truth. He gets up here and lies. He lies to them about the trace. He lies to them about the phone calls. He lies to you about the law. He's just doing anything he can to get his way. Don't give him his way. Don't reward him for being the person that he is. These people that have to protect you while they're watching people in jail, prisons, they have enough to put up with just dealing with the day-to-day stuff and making sure that everybody's safe and everybody gets what they want. But then they have to deal with people like Mr. Peoples. This gentleman over here does nothing but cause them misery, heartache. You heard them. They all have dealt with him. Even Lieutenant Tinker, bless his heart, you can see him trying to be nice and just come on down and get in your cell. And what's he doing? Grabbing the cell, holding on, arguing, and then he starts yelling those words. And I want y'all to remember those words he was yelling from inside that cell.
Buckle up. Here we go.
I'm going to kill. Now, I'm not going to repeat the N word that he used.
Why not?
Don't.
That was being yelled out by this
Why
man in
not,
that
he
cell.
says.
Why would you yell that out over a stupid tray that came from Tuesday on a Sunday, and you don't get your Tuesday tray on Sunday? They don't do that. And the lieutenant ended up giving in to him and giving him a tray. It just rewards him. So I'm asking you, when you go back here, you look at this, it's apparent from the injuries on Lieutenant Ford. And I'm not going to harp on them. But you do need to remember why we're here. We're not here because he didn't get to go get his way. We're here that right there is not from a fingernail. This right here is not from a fingernail. Those are sharp instruments coming down, and it didn't come down because he was trying to distract him. He was trying to get him in the eye, guys. He's trying to poke him in the eye, and he missed. That's why it came down here, and it's down here all the way down because he was swinging. So don't feel sorry for him. You should feel sorry for Lieutenant Ford, who has to go through that every day with this man. Don't reward him for being the way he is. That is not what you do with people who throw fits and try to hurt people in jails that are just trying to make sure everybody's safe, including the people outside the jail. If they're trying to get out, they're trying to harm people in the jail. Do you really think those guys, that this is that important, that all those people would take time out, even people that left, if this man didn't do something that serious? Why did they come up here? And Lieutenant Ford, if you want to think he's a liar, wouldn't it have been easier for Lieutenant Ford to say, hey, I saw him stab me in the eye. He was trying to get me. I saw him swing at me several times. Wouldn't that make more sense if he was trying to lie about this instead of I saw his hands coming at me and then I felt pain and I don't know fingernails or what? Arliss Anderson, who doesn't have anything against him. You didn't hear one thing about Arliss Anderson causing him any problems anywhere else. Comes in here and says, I saw him do it. And then, if you want to know what kind of person he is, just look at all the stuff he even admits to. Throwing stuff on people. Totally causing havoc in that jail. He needs to be put back in prison so they don't have to deal with him. We don't have to deal with him. He needs to go away. But right now, all we need to do first is talk about finding him guilty. Hold him responsible. Don't listen to his wanderings and meanderings. Hold him responsible for what he did that day. Then you can talk about punishment later on. You can adjust it however you think it is. But don't let him just walk away from this. You know what that does? That tells him, you know what? Go do it again. Throw all the fits you want. Do what you want. Then come in here and just go, oh, they're all against me. And everybody just let him go. Go ahead, let him go. If you want him to do this again and just keep on doing this, let him go. Feel sorry for him. Or you can say, you know what, enough's enough. You don't rule this world. You don't get to rule the jail. You don't get to rule this day. And you don't get to rule this court. No matter how hard you try. Hold him responsible. Find him guilty, and then let's get on to the next part, and you can do what you need to do there. Thank you.
All right. Ladies and gentlemen of the jury, this time I'm tendering the jury charge to the bailiff. I'm going to ask you, please step down from the jury, follow the bailiff into the deliberation room. We will await your verdict. By rule of law, only 12 people are allowed in the jury room by law. That means the alternates have to stand out, hold vigil, don't stand up, go outside, relax, stretch your legs. We've had to replace jurors during deliberations before. That's why by law we keep you until the end. But thank you. And you never know, we may be able to pull you into the game here before the end. Thank you for bearing with us.
The jury was walking out as he was talking, like they were moving. We saw them in the bottom video. So they're in the deliberation room. The judge is going to go ahead and put us in timeout.
And we are in recess. Thank you.
I think now, Judge, would be a great time to allow the defendant to put on the record all the things you promised him that you could put on the record. Breaks out the Advil. Oh, wait, no, it's the little bottle. Sure, it's just like saline solution, just rinse and spit type thing. Yeah, burns, huh? It's just like, burns. Okay, waiting for the jury to be in the jury room, for the defendant to go back down the same hallway, because that's what they have to do. We've been muted. And I think he's going to stop the feed here in just a second. Let's see. Little joking with court staff there. Maybe take another swig of water. He can't believe we got to this point. We're not done. We're not done. The jury is apparently going to be, if they do convict, which honestly, I can see the jury acquitting on this charge because of the indictment, because of the way it was written. They're saying, did the state prove this was done with pens? And the victim, when he says when it happened, is after the point where the pens were taken from the defendant by the testimony of the person who took the pens. So you can't have assault with a deadly weapon if it was a fingernail. I can see them acquitting, and I didn't hear any lesser includeds. So... let's go to, do you want to go to Thurston? Well, we're on verdict watch. Let's see, Thurston County is out here. I forgot to set a timer. Sorry. Who's got the timer? One of y'all? Okay, timer's going. We'll just add like 2 minutes to it. Kimberly, welcome. Good to have you here. Mr. Olympia. Looking good. Nisqually's in the house.
Right, in the Olympia Nisqually booth. What's your name?
Daniel Watts.
Shaved head. What's your name again?
Virgil Morgan.
Mr. Morgan. All right. Mr. Rusnak or?
It's me, Your Honor.
Thanks. All right.
We have it's a change of plea. I have 2 plea forms filed with the court of pleading guilty for agreed resolution of credit for time served.
I appreciate that those came in earlier than the calendar so that we could actually get this done. All right. So will there be 2 counts of obstructing? There are 2 plea forms.
So, Your Honor, it should be the city is moving to dismiss on cause number 2021436. And in exchange the defendant to be pleading guilty to the two other cause numbers with credit for time served, 24 months probation, and no contact with Lovers or Walgreens, no new criminal law violations.
And it's
Yeah,
it's
one
in
second. To the same. So is there another one? Yeah, look through that if you could. I'll keep
and it's
going.
in both forms, Your Honor.
Yeah, we're getting the information. I printed something out incorrectly.
I like the green T-shirt for court.
So plea to obstructing and a plea to theft, correct?
Yes.
Okay. All right. So the allegations from May 15th and May 30th. So, Mr. Morgan, that's what looks like you're doing here is you're pleading guilty to one count of obstructing a law enforcement, one count of theft in the third degree. Feel you had enough time with your attorneys to make this decision?
Yes.
Okay. And in these pleas of guilt are all of your rights to have a trial. Do you understand those rights?
Yes.
And do you know that you're giving up those rights to have a trial if you plead guilty?
Yes.
All right. And that's your choice?
Yes.
Okay. And there's a recommendation here. I think I've heard a little bit about it, about credit for time served. And then you'd be released, put you on probation. Your probation would mean that you would not violate the law. And you would not go back to the Lovers package or to Walgreens. And as long as you followed those conditions, then there wouldn't be any more jail time imposed. But in those 2 years, if you didn't,
Is that what she
if
said?
you violated the law or went back to these places, then we'd bring you back to court and potentially impose more jail. Is that what you understand?
Is it a shipping company?
Yes. I do have a question. About
Sure.
the probation is non-active probation?
Well, let's talk about that when we get to sentencing. Right now, I just want to see if I can accept your plea of guilt to these.
Okay.
And then we'll talk more at sentencing about what I should do. All right. So, that's the recommendation. You also have to know I don't have to go along with it.
Yes.
Okay. So I could impose as much as, let's see, the obstructing gross misdemeanor in city, Ms. Vitale, remind me.
This is simple, Your Honor.
Thanks. So the obstructing carries a maximum possible sentence of 90 days, and the theft in the third carries a maximum possible sentence of 364 days in jail.
It's not a shipping company.
And a $5,000 fine. Do you understand those maximum sentences?
Yes.
Okay. Now, I've asked you to make a written statement here as to what you've done wrong that makes you guilty. Are you able to find it? You just found it? Okay, we're going to slow down here for my clerk for a second.
It's not a liquor store either. I think they sell dainty somethings.
Good job. That's right. So the statements that you made about what you did wrong makes you guilty. First off, as to, let me get to it.
It's one of those silk and lace stores.
Third degree. You're saying on May 31st of 2025, you stole $81.18 worth of tequila from the Walgreens on 1510 Cooper Point.
Tequila.
Do you accept that as what you did wrong?
Yes, ma'am.
And then as to the obstructing, you said on May 25th of 2022, you intentionally resisted, obstructed, or delayed a person who you knew was a public servant or an officer acting in their official or their governmental capacity in Olympia. Do you accept that as what you did wrong?
Yes.
Okay. Now, has
Peter
anyone
Tupperware.
threatened you with harm or made you any promises that have caused you to plead guilty?
Thank you.
No.
Thank you, my friend.
Okay. Well, how do you plead to theft in the third degree?
Guilty.
And how do you plead to obstructing law enforcement?
Guilty.
How much is $75
Well,
worth
accept
of
your pleas of guilt,
tequila?
sir, and I'm doing that now, finding you know what you're doing. You're doing this voluntarily and intelligently. I find that you're doing this understanding the consequences of pleading guilty, and your statement there supports this on both cases. So we'll move to sentencing, and I'm going to hear from the lawyers, and I will turn back to you then, and hear from you and answer questions. So, Ms. Vitale?
Your Honor, the case the city dismissed was a theft from 2021. He's pleading to an obstruction from 2022 and a theft from 2025. Unfortunately, because of the failures to appear, bail was set, and he's already at this point, I think he's completed 23 days in custody on these charges, which is, I think, more than he normally would had there not been failures to appear here. So I do think it's fair and appropriate that he get credit for time served at this time, to have a bench probation, just not to go back to these locations and have no new criminal law violations. I think he has served his time on these. I think it's fair and appropriate, and I would ask the court to follow the recommendation. Thank
TSN, you are an OG.
And
40,
Ms. McCarron?
41 months.
I agree with Ms. Vitale and just reiterate that I asked the court to follow the recommendation and to do a bench or inactive probation as he's more than served his time on these charges.
TSN, thank you. Thank you so much.
Well, Mr. Morgan, anything you'd like to add to all this?
I will stay away from those places and I won't have any more criminal violations.
That's all we ask. That's a good plan.
And I'm asking bench probation, do I have to report at all? Or do I have to report once or something and that's it? Or how does that work? Because I've never had that.
Yeah, good question.
If I need to report one time, I need to know if I need to report one time is what I'm saying. Like, and where to? Because I don't know where to because I've never had that kind of probation. So
right, I understand. Let me answer that question for you. So what it is my probation department's going to check your record, make sure you don't have any new law violations, that you don't go back to the Target or the Walgreens and the Lover's Package. And so I don't expect you checking in with them. I don't need you to check in with them.
I think the Lover's Package is like chocolates.
If they contact you and want you to come in, then you gotta. But I don't expect that as long as you don't violate the law and don't go back to those two places, all right?
Okay, so I'm free when I walk out of here then?
When you walk out of there, you don't violate the law and you don't go back to those two places and you're good to go.
Okay, thank you.
All right, good. Okay, any other questions?
No.
All right, well, you can let yourself out of there and I'll get these orders down to you.
Let yourself out of jail.
Right, thank you.
You're good.
You're welcome.
No more Walgreens, no more tequila.
Your Honor, that's my only matter for this afternoon. May I be excused?
Sure. Have a good night.
Thank you.
Your only matter. And we have 4.
Is Ellen?
Be right with you. 1 second.
Thank you.
It's like, I'm here now. Can we start? Hang on, sir. There's people in line. Fun fact. The judge has not left the bench yet. He's still sitting there. He thinks the jury's going to be right back with the verdict. He's holding tight for this one, and see what happens. Affiliate link for those lovers of chocolates. I'm working on that one. I'm still working on the affiliate. Got my application in. No. It's not a shipping company, and I don't think they sell chocolates.
They put all the time on the theft.
And if they do, I don't want the ones they sell. Just saying. I ordered a new set of headphones because these ones are falling apart right here. Like the little parts are flaking off. The pleather. Oh, man. They do sell some edibles of some sort or another. Yes. Olympia's really lenient. Y'all promise to stay in jail? No letting yourself out? All right.
Sorry.
All right, we have received a verdict in this case. Stand by. Thank you.
Oh, did you hear that? We have a new record verdict. Yes, by my count, check this out. 11 minutes and 20 seconds. We can add 2 minutes to that. Still under the 15-minute mark. The jury comes back with a verdict in the People's Poop case. The pen case. The pen is mightier, excuse me. The People's Poop pen case. It did not take long. I'm not even sure if the jury sat down. Many juries are not able to even find a foreperson in the time this jury was able to do that and fill out all the verdict forms. Either Mr. Peoples convinced them so easily that they saw immediately the failure of the state's case.
The verdict shall show that the state's attorneys are present.
In fact, the state has prevailed.
The court has received a message from the jury that the jury has reached a verdict in this case. Please bring the jury out. We will receive the verdict. Thank you. We also need alternates from outside to be brought in.
The judge,
the two alternates,
sees the light at the end of the tunnel. He's looking forward to the day when poop and pens are not mentioned in his court, at least not in this context.
They don't have a verdict?
I tried to ask him. He keeps telling me, hold on.
Maybe some of the restroom or something. Oh,
yeah.
We'll see.
Let's see. That's what happens sometimes. They go with
How poetic the jury, after reaching a verdict, is not ready to come out because they held it. They held it while they awaited. They I need to go real bad. Maybe number one, maybe number two, but I will hold it while we hurry and vote on this one. And then they sought relief after filling out the verdict forms, which we'll be hearing in just a minute. You can't make this stuff up. Oh my goodness! Someone has to use the facilities. We're just waiting. We're just gonna hold tight for a bit. It's like the jury. You know how it's like a false alarm, or they pop up and then it's not there. It's not like whack-a-mole. It's like a prairie dog. They're prairie dogging. No, that's different. No, you can't say prairie dogging. They're going to be popping up here shortly, after a short delay. We'll have everybody here in a moment. Oh my goodness. I wish a penny for your thoughts, Judge. This has been a rough one for him. He's taken personal offense. You can tell a number of times when the court is impugned with this testimony, as we get to see the jurors come in this camera, because we can see them. Are we ready? Are they ready? Do they have a verdict? He says. Yes, we have a verdict. He says, bring him in. Do we? Do they change their mind? Tell us, Judge.
So it wasn't the jury that said, wait a minute, it was Pickles that said, yes.
Jury files in. Defendant said these are not a jury of his peers. We see it's very diverse. Final juror comes through, makes its way over to the jury box to take a seat. The door closes.
And the record shall show that the jury is in the courtroom. All parties are present. And you, sir, are going to be, your name, I'm sorry.
Dallas Stanley.
Okay. Stand by.
Of course, the jury foreman's name is Dallas. We are, in fact, in Texas.
Yes. You're juror number 28 on this. You are the foreperson of the jury. We have received a message on behalf of the jury that the jury has reached a verdict in this case. Is that true, sir?
Yes, sir.
Is this verdict a unanimous one? That is one that is agreed upon by all members of the jury.
Yes, sir.
Do any of the jurors, fellow jurors, disagree with your foreman's representations? No disagreement is indicated. It does appear to be unanimous. I'm going to ask you pass the documents to the bailiff. I'm going to review for proper form, and I will publish the verdict. And in cause number 23, the defendant shall rise, please. In cause number 23, CR 727, we, the jury, find the defendant guilty of the offense of aggravated assault against the public servant as charged in the indictment, signed by the jury foreperson. And this again is 23 CR 727, the state of Texas versus Raymond Pickles. The jury verdict is received. It is made a part of the record for all purposes. Ladies and gentlemen of the jury, at this time I have received and accepted your verdict finding the defendant guilty of the offense as charged in the indictment. That brings us to a close of phase one of this two-phase trial. We will be proceeding with the punishment phase next. And let me repeat once again, you still are under all instructions previously given to you. Is the state and the defendant ready to move forward with the punishment phase of this trial, state?
Yeah.
And Mr. Peebles?
Yep.
All right. The state, you have, there is a second paragraph in this indictment, ladies and gentlemen. And at this time, I'm going to ask the state of Texas to read and make a formal statement of this second paragraph of the indictment. Go ahead.
And the grand jurors aforesaid, upon their oaths aforesaid, do further present in and to said court at said term that before the commission of the primary offense, the defendant was finally convicted of the felony of aggravated assault, second degree, on April 22nd, 2021, in cause number 16-24808 in the Criminal District Court of Jefferson County, Texas.
And that is signed by the foreman of the
Yes, sir.
grand jury. Raymond Pickles, you have just heard the reading of paragraph 2 of this indictment, which states that you were finally convicted of aggravated assault on April 22nd, 2021 in this Criminal District Court of Jefferson County, Texas, in cause number 16-24808. Is that allegation true or untrue, sir?
The fact that you have no jurisdiction is not true.
All right. Untrue will be entered into the record on your behalf. All right. The state of Texas?
Yes, sir. We'll need to take a break, get your fingerprinted so we can.
The double negative got him.
We're going to take a break, ladies and gentlemen. Relax, stretch your legs for about 5 minutes, 10 minutes, and we'll bring you back in. And what is the state's prediction for presentation of punishment evidence?
It'll be brief, Judge.
Okay.
They've already heard enough in guilt innocence phase, and then I'm just presenting these.
Okay. All right. Take a break. Thank you, ladies and gentlemen.
Oh my goodness. We're getting there. This is going to be quick. We get to hear the verdict music twice in one day.
It's been done. It's been
Okay, so, okay, okay. That's what I need to do. Almost wrong. Oh, gosh. But that didn't get us nowhere.
And we are in short recess.
Yeah.
Get my light working here. All right. The judge says we're in short recess, which means, well, if he's got a hot mic, we're going to stay here. Are you going to mute us? I haven't seen the judge this happy all day.
Here, Weird. Mr. Peebles, this is not a plea bargain case. You have an absolute right to appeal. I've signed the document
I'm reading somebody's
on
palm.
that. And the bottom is, the bottom is for you to sign your acknowledgement of the receipt of that, and you will get a copy of that for you and your records.
I would like to give the court notice of arrest of judgment.
Okay.
Arrest of judgment? You need to sign it first. Ask the judge if you can borrow his pen.
That's, he's given notice of it, and just put it in the record.
Just want to make sure I ain't found my life today, but you know, white people hate my guts or anything.
What? Prosecutor heard that, looks at the judge and says, did he just?
Yeah, we want a little bit of warm up.
And everything says.
I don't know how long this is going to take.
The defendant only has himself to blame in this case, where he admitted to the charges.
Hey, on that, that's so big fishing for Bill. Which one? Which one? Is it the last one? And no, it's doesn't say, but that's the last two. The last two, the pink and the orange. Okay, thanks.
Judge knows the law, but the process of how to fill out the paperwork is tricky.
Okay.
So many
Here,
carbon
I'm going to
copies.
give Mr. Peoples all three of these copies, and we're going to only need the top one. He gets all three for whatever purposes he may wish to use those for. The other stays with this.
Mr. Pickles, I'm gonna need to get a fingerprint of your right thumb, and then for the purposes of the prior allegation, when you, on your judgments, or comparison of the judgments. Well, they're not allegations, they were judgments, they're completed and final. I misspoke when I said allegations.
Just make sure that they belong to you.
Put the last name for me.
P-E-O-P-O-E.
R-A-Y.
What's the other one? Second.
That's all right?
Yeah.
It's 30.
How much you weigh?
And all the other, wait,
Rough as
That's why we asked.
brown eyes,
yeah.
black hair. You know, social security number?
We're
So there was,
gonna turn that off. He's getting all his information.
Was that all collected afterwards? Yes, because that's a very fair question.
The penalty on this
So we'll have
case.
to wait for the sentencing for tomorrow or something?
no, we're gonna do this right now. Be your right up on. If you don't mind standing up for me, just go stand right here.
Could take
Get
a
you
picture.
to pump it a couple times. Sometimes it gets a little thick, so just press your thumb down right there. For me. All right, don't press super hard, but just press right there for me.
Get your fingerprints.
That'll be it. That's all I'll need. I'll get you send me one. Oh, he's got something. Mr. Peters, I need you to sign right here.
Judge mutes it. We don't get to hear the part where he's handed a pen to sign. Bad things can happen here. Mr. Peoples said he would show good decor for his kids. And apparently he's doing that. I was expecting an outburst, but we have not seen that yet. although the night is young. Going to be bringing the jury back out. They're going to have very brief presentation of evidence. And even, I would say, even more brief arguments where Mr. Peoples will once again be able to speak to the jury and probably berate them for their decision, is my guess, if I had to put it out there. And then the jury gets to make a recommendation as far as sentence. And I believe the maximum sentence is 20 years. Judge might be looking this up right now just to make sure for this charge. And I can guess that this verdict may be even faster than the previous one, as they already have a jury 4-person selected now. This could be a new world record with a 5-minute verdict. Maybe this judge will get another award from the president for the fastest deliberation, presiding over the fastest deliberation ever. We're just going to chill out here for a moment while the judge does some light reading. Smiling for the first time today. I think it's 20 years. He's done 7 already on a 10-year, I think. Now he's going to get some more tacked onto that. I'm confused if they're deliberating now. No, they found him guilty on the guilt and innocence phase. Now they're moving into the punishment phase, where the jury makes a recommendation separate from the guilt and innocence, where Max's life for 99 years. I think that's what Mr. People said. I'm not sure if that's the case. Aggravated assault with a deadly weapon. Life seems like a long punishment for that one. Adam, good to see you, my friend. We've missed you. Hope things are going well with everything in your world. Read that somewhere, but I might be wrong. It seems steep, because it is such a it's a lesser included of so much more serious crimes, and if it is life in prison without parole as a max for that, there's not much higher you can get other than death penalty. This is where his master plan comes in. The jury's on his side and gives him negative 30 years. Bailiff is on her phone. I'm sure it's a work phone. They're communicating about shifts and security issues over Tinder. I mean, over text, excuse me. I misspoke. Oh, man. We might have to let Adam participate via comments if he goes back and rewatches. Google says Texas carries a minimum of 2, maximum of 20 for aggravated assault. So 2 to 20. I was thinking 2 to 10, but 2 to 20. The jury can consider priors. They can't consider pendings. But the defendant let them know about that. Plus the enhancement for weapon and public official. To add 5 or 10 for that. I never ended the poll on the jury deliberation. Who started the poll? Hang on, let me end this poll. The mods were hard at work. How long will the jury deliberate? 30 minutes or less, 53%. Review were right. 45 minutes to an hour, 40%, and 2 to 3 hours were 7%. So majority wins on this one. Thank you, Josh, for putting that together. I completely neglected my duties in that portion of the coverage. Let's see if we've got everything in order. The judge anticipates that we're going to be ready to go in just a moment, keeping the live stream going. Hasn't even left the bench. He's on a roll. There we go. Are we ready? Can you unmute us, Judge? Don't do us dirty like this.
Hello?
Procedural matters, and unfortunately you have not.
Judge, over here. Unmute. Lucky number 13 for the best trial ever. 13 months. Cody Height, thank you very much, my friend. Appreciate your support. Judge, look over here. Look at us. We're muted. Prosecutor is presenting a little bit of evidence. It's basically pay attention to everything I've told you before. Oh, you touched the mic. You broke it.
Hello?
Judge, look at us. Remember, we're muted. Please, Your Honor. Oh, there we go. Thank you.
This is what it is to take a known print, compare it against a print that's on a judgment to see if it's the same person.
So is it possible to take an unknown print and match it to a known print?
It is.
And what is the process of looking at a print to determine whether or not it's the same?
So all fingerprints are biologically unique. They're every person different fingerprint. No two are alike. It's scientifically impossible. So what we do is you take a fingerprint, a ink print, you transfer that print to a fingerprint card. You look for certain points, identifiers, and you compare them to the print that is on the judgment to make that identification.
And did I ask you to fingerprint a certain individual today?
You did.
Who did I ask you to fingerprint?
Raymond Pickles.
And do you see Raymond Pickles in the courtroom?
I do. He's wearing a button-down white long sleeve shirt that's rolled up at the sleeve.
Record reflect he's identified the defendant?
Yes, it will.
Let me show you what's been marked as State's Exhibit 41. Do you recognize this?
Yes.
And what is that?
State's Exhibit 41 is a fingerprint card with fingerprint and information of Mr. Pickles.
Okay. And it's Mr. Pickles. What finger is it?
That would be his right thumb.
And why did you just take the right thumb print?
So on the judgments, they are used, a person will use the right thumb, predominantly most of the time.
And did you have Mr. People sign this?
I did.
And did he sign it?
Yes, he did.
And did you get all his information stating this is his thumbprint?
I did.
Did he use a
And
pen?
states 41.
Any objection, sir?
Yeah, objection.
What's your objection? You just object generally?
What's the point of this?
All right.
I'm not understanding what this is.
You've been to, sir, this has happened before.
This
You know, he's asking you, do you have any objections to that being admitted in?
This is just a fingerprint to prove up these two judgments that you wouldn't be true to, so I just have to prove them up with the thumbprint. So, yeah.
Thought this was just the aggravated assault. Well, where the other judges come from?
Sir, as you are well aware, once you are convicted in sentencing, the state of Texas is allowed to present proof of other criminal convictions and other information to help the jury make its decision, since a decision on punishment is based on criminal history and the circumstances of the offense. We're going to this, the prior criminal history does not come into play until the punishment phase. This is what this is for. Are you objecting to that state's exhibit?
Not that I understand, no.
Okay, then the state's exhibit 41, the fingerprint card of the defendant, is admitted.
So let me show you now what's been marked as state's exhibits 39 and 40. Can you identify those?
Yes, you can.
And what are those?
These are judgments.
And are they judgments and convictions of one Raymond Pickles?
They
and are purporting to be.
That's correct.
And did I ask you to compare state's exhibit 41 with 39 and 40?
You did.
And did you compare those?
I did.
And in your opinion, is states 39 and 40 the same person whose fingerprint is on state's exhibit 41?
It is.
So is that fingerprint, in your opinion, on both of those judgments, Raymond Peoples' fingerprint?
It is.
This time, Judge, I'd like to tender both certified copies of state's exhibit 39 and 40. Let's do this. Why don't we identify 39 as what's the cause number on 39?
39 is cause number 16-24809.
And look at state's exhibit 40. What is it?
State's exhibit 40 is cause number 16-24808.
We tender states 39 and 40, Judge.
Okay.
Have any objections?
No.
Sir, any objections?
No.
You said no. All right. Without objection, state's exhibits 39 and 40 are admitted.
So look at state's exhibit 39. And if you have to, I'll blow it up for you. I'm going to blow it up pretty good. This is cause number what?
16-24809.
And it's the state of Texas versus who?
Raymond Peoples.
And what is the charge?
Attempt to take a weapon from an officer.
Oh.
And the offense date?
Was 3/29/16.
And what type of felony is this? What degree is it?
This state jail felony. Mr. Lurk, could you go back one?
Sure.
So 3/19/16. Yes, okay.
So it's a state jail felony, is that correct?
Yes, sir.
And it says this was a plea to a motion to adjudicate. Is that true?
That's correct.
And is that that's a revocation of probation? Is that right?
Yes, sir.
And does it say underneath that he pled true to 2 counts under that 3 and 6?
Yes, sir.
And that he pled not true to 7, 8, and 9. Is that correct?
Correct.
And what does it say that the confinement was, the punishment was for this?
2 years in state jail division.
And what date up here was this date of this sentence imposed?
4/22/2021.
Now looking back at the indictment, what does it state that he was charged with here where it says he did then and there do what?
The intention of harming Christopher Rinkmeyer intentionally, knowingly, with the force attempt to take from Christopher Brinkmeyer, a peace officer, the officer's firearm.
So the weapon he attempted to take from the officer was a firearm, is that correct?
That's correct.
And just to make sure we know, on the part of this is, when we do plea papers, do they also have to sign what they call a judicial confession?
They do.
And down here where it says, I have read, can you read what that says?
Yeah, I've read the charging instrument, and my attorney has explained to me, and I have committed each and every element alleged.
And does it say down here under this that they swear to that?
Yes, I swear that all of the foregoing, as well as the testimony I give is the truth, so help me God.
And
Signed
that's it?
by Raymond Pickles.
Okay. So he signed a judicial confession saying he was guilty of that offense, am I right?
Yes, sir.
Okay. Now let's look at State's Exhibit 40. What cause number is this?
16-24808.
And would that match the cause number in the indictment that I just read, which is cause number 16-24808?
That's correct.
And is it State of Texas versus who?
Raymond Pickles.
And what type of charge is this?
An aggravated assault.
And the date of the offense?
3/29/2016.
That the same as the last offense too?
It is.
And what degree was it?
2nd degree felony.
And again, was he a revocation of probation?
He was.
And did he plead true to 2 counts, 3 and 6?
Correct.
And that counts being, those counts would be violations of his probation, correct?
That is correct.
And then he also pled not true to 7, 8, 9, is that correct?
That's correct.
And what was the sentence that the court gave him?
It was 20 years in the Institute Division of TDCJ.
So that's 20 years prison, is that correct?
That's correct.
And was there also a deadly weapon of a firearm?
Yes.
And up here, what was the date of that sentence imposed?
4/22/2021.
Now, both of those being on the same date, both of those would have run concurrently or together, is that correct?
That's correct.
And both of them, he was placed on probation, and both of them, he was revoked, is that correct?
That is correct.
I'll pass the witness, Judge.
I got your name, but
Troy Robinson.
Troy, Mr. Robinson. So the day, did you recognize?
Those 3 words right there, that's in the middle of the screen. Do you know, can you read? I'm reading that a lot. Judgment adjudicating guilt. Do you know what that means? Judgment adjudicating guilt?
Yes, you're guilty.
Now, deferred.
I'm sorry.
When they say deferred, right? He don't have that paper. But if you put the word deferred right there, what would it be?
It'd be deferred.
Well, like what do that word?
If I guess in a situation, hypothetically, if you were put on deferred probation and you completed your probation without violating it, the sentence will be deferred and you wouldn't be considered guilty of it.
So, in other words, the day that I signed and agreed to this, right? Deferred adjudication, probation, right? It's probation that he's saying, I pled true. You see how you pointed to this and said I pled true? Those counts was because I was on probation, correct?
That would be correct.
So,
I'm not sure what for, but.
Right. Attempt to take weapon from her. But the thing about it is, the fact that I was on probation and if they said deferred adjudicated probation, right, that would mean a delayed judgment, correct?
I can see what you're saying, but I'm not familiar with the facts of these cases, so
well,
I don't know your history other than what I've been presented.
Well, I'm not exactly asking about the fact.
Well, I'm not an attorney either.
Oh, okay, so there we go. So
there we go.
Just for a little education, deferred means delayed, right? adjudication means judge, pronouncing a judgment, right? Probation, well, we know what probation means. So which means the day I sign for probation on a probation like this, deferred adjudication, which means I wasn't found guilty that day. You ever heard of that kind of?
I mean, you're asking me or telling me?
I'm asking you, have you ever heard of if a person signed for deferred adjudicated probation that and
Where's
the
it going with
judge
this?
agreed and announced it, right? Do you remember? I mean, have you ever heard of it not being a judgment until that person is violated?
That's a little bit out of my wheelhouse. I was, the whole dynamics of that.
So how do you understand?
I'm familiar with judgments, reading them, going over what the person was convicted of, and processing the print from the person you compare it to the person.
But you don't understand the difference in the common judgments. You just know it's a judgment.
Well, no, I understand what they're asking.
You do?
But I mean, I'm not sure what question you want me to answer.
Do you know what deferred adjudicated probation is?
Yes. I explained that a second ago.
Right, that's why I'm not understanding why you said you don't understand.
Well, I'm not sure what question you're asking. You had like a 4-part question there.
Okay, I signed, the day I signed that you said, he just showed you my signature, right? Signed for, and the day the judge agreed to, right? And established that I signed.
It's no longer deferred at that point. So.
It's not?
No.
So what do?
You were convicted of it.
I was convicted that day.
Correct. The date that's on there, I think it's, I'd have to see the judgment, but I think it's on the right-hand side. It's for, no.
Yeah, look at the other way.
Other way.
Other way? Oh, yeah, right here.
No, right-hand side. Oh, yeah. Date of sentence, 4/22/2021.
So that was the day I was sentenced, right? Judge, that was the day of judgment, right?
Yes.
Do you, that paper that you just had on my signature, where is it?
Sit there.
That was it, that's the same part of the exhibit. Towards the back. You see it? Yeah, but oh, there it is. So it's
He's now proving to the jury that he's been convicted of this crime. So just give him a minute. Prosecutor's going to let him do this job for him.
Yeah, we just yeah, we just don't answer the symbols like this, right? So my signature is on this paper. Do you know what that means right there?
Your signature's on that paper?
Right. Like this is the start. The fact of, do you know what it means for this sentence to have that date?
Yeah, that's the original community service supervision order.
Right.
The day you were placed on probation.
That was the day I signed, right?
He's got some big fingernails.
For probation, correct.
Right. So
got to be careful. Those
if
could
the
scratch
day
somebody.
that I was judged is right here, and the day that I signed is different, how was I found guilty on the day that I signed?
So what you have here is you're just showing us one piece of paper. The whole packet, which you guys will be able to look through, is considered like it's a court packet, right? It's going to be a certified copy from the district clerk's office. It's kept in their regular course of business. We get the certified copy, which is going to have all the information in it, along with his fingerprint, that the attorney directs to use. So I mean, there's several more pieces of paper. There's probably like 10 or 12 pieces there for that one package that will explain all of it.
We don't shoot both of those and should let you interview just with us. Perfect. So when I asked you earlier, you said the day that I signed was the day I was found guilty, correct?
I would need to see the piece of paper you're talking about.
No, earlier when I asked you, you said the day that I signed that I pled guilty was the day I was found guilty, correct?
So I wasn't here for your signature. In regular court, what would happen is when they sign for their, like for instance, 422 and 21, is when he was convicted, he would have to sign, give his fingerprint to the clerk, and it would go from there, and the conviction would be filed over at the district clerk's office, which is pretty much the same thing, if I'm not mistaken, that they do for when they're put on probation. They would receive probation with the judge, they would go next to the clerk, they would signature, fingerprint, and they would go on.
So are you explaining that I signed something April 27th, 2021?
I wasn't here for you to sign it, but in the document, your signature's there.
But that's absolutely not true. When the judge found me guilty, I walked out this courtroom without signing nothing at all.
I would have to defer to the attorney or the judge on that. I wasn't for that.
Is that correct, Mr. Lynn?
What, you didn't sign for anything?
Did I sign something that day?
I don't think you signed anything that day. It doesn't matter.
No. Well, it absolutely matters because you said you understood this, correct?
I do understand.
Here it goes.
And you did earlier when I asked you the day that I signed, was that the day I was found guilty?
And I said this, I would have to see the piece of paper.
So you didn't say that, yes, that was the day he was found guilty. You didn't say that.
Okay.
I'm asking, did you say it?
I would have to have it very back.
No, I'm talking about, or you forgot?
You've asked me a lot of questions.
I called him for fingerprints and to compare it to the judgment. I just had him read off the judgment. If he wants him to read off of it instead of explaining it, I don't have any objections. Otherwise, he's gonna keep asking the same question, get the same answer.
I'm trying to get him.
I object
question
to just being outside of this witness's expertise.
I'm trying to get him to answer the question from his understanding.
He can answer if he's able to, under what part he played in the review of these items.
Right, that's why I'm asking you earlier when I was asking you, do you remember saying that the day that I signed is the day I was found guilty?
So that judgment was completed on 4/22/21, correct?
Yes.
Okay. That paperwork was filed for that date, and all the information in there is certified for that date of sentence commuted. So I was not here for your signature. I did not see you sign it. I'm telling you, it's in the packet.
But do you understand my question?
What is your question?
Earlier when I first asked you, the day that I signed for probation, is that the day I was found guilty? And you said, yes, that is the day you was found guilty. Do you? I'm asking you.
You're asking it that way.
Judge, the state of Texas will stipulate that the day he signed for probation was deferred probation and he was not found guilty at that time. He was found guilty on April 22nd, 2021.
That's the law.
All right. Now I'm getting somewhere, which means
Now we're getting somewhere.
I wasn't found guilty on the day I signed for probation. So why did you go through all this and present it as if I was found guilty under my signature?
Are you questioning him? You're questioning this witness, not Mr. Laird.
Oh, okay, right. So why is it y'all went through all of this as if I was? You just can't fingerprint me, and you trying to add. And you said you compared it to the day I was found guilty, right? And you, because I guess y'all doing it because I said, I don't agree to the priors and all of that.
We don't need any hand motions.
I'm assuming that's why y'all went through all this.
On paragraph 2, the aggravated assault conviction on April 22nd, 2021 is alleged in paragraph 2 of the indictment, which comes into play for sentencing purposes.
Ricky,
we read
thank
that.
you so much.
I read it.
Appreciate
you
it.
Pleaded untrue.
Right.
Then the state, to prove that up, did what they had to present evidence that you were placed on probation at one time, and then that probation was deferred or unadjudicated probation. It was revoked, and the court sentenced you subsequently on that date. And that's to prove up what is alleged in paragraph 2.
Right. So I said the judgment is not true or whatnot. And you said it is true because I signed it on that day, right?
What's your question?
What is the point of it?
Now we're getting.
I'm gonna object.
Yeah, sustained. That's.
Yeah,
The jury is listening to the evidence and they'll decide how much weight and credibility to give to it. You don't make an editorial comment, just ask questions. So, but under the rules of law, when somebody is placed on deferred or unadjudicated probation, that is a kind of a newer type of law that came into effect, which is a good thing. The old traditional probation, you were found guilty, sentenced, and your confinement was suspended, but you were convicted. And so a conviction has its difficulties on people. So subsequent to that, the legislature came up with what's called deferred or unadjudicated probation. A jury cannot give deferred probation. They can only give regular probation. But if a defendant pleads guilty to the court, then if it's agreed upon by the parties, then the court can defer any finding of guilt. And they're put on terms of probation which are similar to regular probation terms. You don't commit crimes, and there's 34, 35 conditions, and most of all those conditions are the same conditions you and I have to do every day. But if on deferred probation, they're not found guilty unless during the course of probation, they commit violations of their probation, then a motion to revoke probation can be filed by the state of Texas. And then that is heard by the court. If the court finds by a preponderance of the evidence or greater, which is the same test in a civil court on a motion to revoke probation, it's less than beyond a reasonable doubt. If a court deems that it's been proven while on probation, they failed to follow the terms of probation, then the court can revoke probation and sentence them to the full range of punishment that they were subject to. They, by that point, are found guilty and sentenced. And that is the way a deferred or unadjudicated probation works from beginning through the process if a motion to revoke probation is filed and then it's revoked and sentenced. This court's, I'm just going to, editorial opinion, 93% of my probationers are successful. The average is about 75% for the country, and we have a 93% success rate in this county.
You, sir, are one of the 8%.
So, I'm very proud of our probation office in the way they handle probationers and escorting them through probation. But that's the way generally a probation works when we have what's called deferred or unadjudicated probation. Okay, go forward.
I'm sorry for the broad question. I'm gonna make it. I'm gonna ask you a more substantial question.
Oh, goody.
A second ago, District Attorney Mike Laird confirmed that was my signature. And you confirmed to him that was my signature, correct?
On which document?
On this document that we're looking at.
What states exhibit is that?
States exhibit 39.
Do you need to see it?
Yes, I would like to.
Yeah. I'm going to ask the bailiff. Hold on. Let the bailiff, if you would be so kind, pass that document to the witness so he can review. Thank you, sir.
Yeah, bailiff, run interference. You're convicted now of aggravated assault. Let's try to keep you away from witnesses.
Question, sir?
Did you confirm with the state that was my signature on that document?
Yes, on States Exhibit 39, clause number 16-24809, on the very last page, in which I read earlier, speaking with Mr. Laird, is your signature along with your thumbprint at the bottom that I use for comparison.
Was that to prove the judgment of that document?
There's actually more than one fingerprint on this. Used every fingerprint that is here. There's also a fingerprint on page 4. Page 4 of this document as well. And so both fingerprints were compared, and they compared to your fingerprint on State's Exhibit 41.
What was that to prove? What was it to prove that that judgment on that document?
That was to prove that the same person on the fingerprint card, you, Raymond Pickles, is the same person who put their fingerprint on this judgment.
That's
State
all.
Exhibit 39.
That's all.
it.
That's all.
Yes, sir.
Okay. No further questions?
Anything else?
No.
Is this man excused?
Please, Judge.
You are excused.
Judge.
Next, please.
Rest, Judge.
State rest. Mr. Peoples, anything you want to present for punishment purposes?
Yeah.
Can you think of anything you'd like to present
that's relevant
to the jury to help them? Because on the punishment, it's about character. Did you want to
call
make a
yourself a
summary
character
of
witness?
what you want to tell them about you?
No.
Okay. No. Ladies and gentlemen, the parties have rested. I have a proposed jury charge that I need to review with the parties and then read for sentencing. It's 4:45.
Oh man, you're
I'm going to do what
another
y'all
day.
want. Would y'all like to break for the evening and then come back tomorrow and deal with? No. Yes. Oh boy.
We have
We've
division.
Well, here's. I know you like to move forward, but it's going to take. The parties get to review it, and if there are any changes, I've got to make the changes. It's going to take probably 15 minutes or so for everybody to look at it, depending upon how fast they want to read through this. And then if there's no objections, then I can read the jury charge and y'all can go and deliberate. If there are some changes, y'all got to bear with me to make the changes. What do you want to
closing
do?
arguments?
I'm going to do what the jury wishes. It looked like we had about a half on one side, half on the other. Does anybody, let me ask you this, does somebody have a time problem that you need to get to this evening that you just can't stay a little later? If you do, let me know, because you do, ma'am? All right, well, that carries with everybody. If it's just one, and that's okay. Yeah, but no, but an alternate, I've changed alternate, I've included alternates during deliberations. We've lost jurors during deliberations, sir. That's the way it is. It's just the way they have to be present to listen to the arguments and to make a decision. And it is the court's decision on the timing. Ladies and gentlemen, if one person can't make it.
Please don't make me.
No, I'm sorry. You don't run things, sir. If one is released, there's always a chance we could have a problem. That if two people couldn't serve out for some reason, and it has happened, then without the alternates, then we are mistried, and that's not going to happen. The mistrial means you have to start all over again.
You'd actually just start over with the penalty phase.
I'm going to ask you to return back at 9:30. Please remember the instructions the court has given to you, and this, it's people generally.
People do not want to convict. I don't want to convict.
I'm sorry, but we work generally until 5, but when there's a problem, all the jurors have to be available, and it's a regular work hour until 5. So are you sure?
She's
okay,
like, I'll
y'all want to stay?
I'll stay.
And get this accomplished? Is anybody else? Okay, it looks like everybody's with us. All right. We're going to take a short break while they look at it for a few minutes. And if it's fine, I'll read the charge, then you'll go and deliberate. Okay. All right. Thank you, ma'am, for working with us. All right.
Everybody queue up for your sharp break and don't go. Don't go. Yeah, we're going to stay here, and we want this done today. We're really pushing for that music. It's the only saving grace that we might get out of this. Oh, my goodness. I think that this case has been just absolutely charming. Charming. It's just been.
Yeah. I think we're good on it.
We've gone through both parts. We've got the first. I guess it's the two-ply case.
All right, we're in short recess.
It's two-ply. So judge is going to head back into the outhouse, back out to his chambers, and we're going to go. We're going to go on. One juror says, "I've got something I can't miss." And the others are like, "Please don't make this go another day. Can we replace her with an alternate?" And the defendant now comes to the jury's aid. "Judge, I don't want to make these people come back. They don't want to come back tomorrow." It's like now you're trying to win their hearts and minds. We can't hold it in for another day. Oh my goodness. I'm doing verdict music on my phone and watching the current on TV. Yeah. Why did the toilet paper roll down the hill? To get to the bottom. That one juror just about was ready to receive death threats from the rest of the jurors. They would like this done. And we would as well, quite honestly. I'm ready to be done with this one. Tomorrow, after all, is podcast day, which I have not done anything for yet. So I need to be looking around for stories. If you have suggestions of stories, don't put them in chat. Don't spoil it for everyone. Send them straight to the burner phone. I'm just going to put this out there. Maybe no poop stories. Let's just, we're going to raise the bar. We're going to do better on the podcast. Normally, a little bit of toilet humor might find its way into the podcast, but after this week, I say we need a reprieve from the toilet humor in the podcast. So we'll see what happens. I might find a story and wait, but this one has to be in there. All right. Let's see where we're at. Sometimes it rains and it pours, and testing chocolate milk. I'm down with that, but it has to be a full gallon. We're gonna do the gallon milk challenge. What do you think? I don't have anything to taste test this week. I could run to the store tonight. What do you guys? Are there any suggestions? I think it's not fair to throw something like that, to dump that on Thomas, without giving him a chance to find it as well. Oh, man. The other day there was a police chase. We're not going to watch it here, but it was in L.A. and it was, I believe, the defendant or the suspect was in a white 4-door little car and was zipping around all over the place, possibly armed, stolen vehicle, possibly armed, and it went on, and there was one point when they had the most L.A. police chase of L.A. police chase moments when the car made it back onto the 10 freeway or something. I forget which road it was on. And right as he merges onto the freeway, I believe it was a he merges into a group of youngsters on dirt bikes who were doing a freeway takeover wheelie event. You cannot make this up. It's like one crime merges with another. The motorcycles wisely determined that they were outgunned in that situation, and yielded to the car and didn't start a chase or try to block the police or anything else. But it was nuts. It was on Credence and Mikey. Yeah, go watch it over there. It was funny. It was so funny. The mods and I watched this live, and we were sort of using mod chat. They were using mod chat, and me too, to comment on it as it was going down. But it was nuts. Each of you find most interesting titled book from bookstore or thrift shop. Have a book review online. That would involve reading, surely not. I enjoy reading books with my wife. Like we'll find a good mystery book or something and read it. But I don't read as much as I used to, unless it's court documents. Then I read a ton. Taste test cereal. It's all good, but you need the milk with it. The judge is a little bit frustrated because the defendant just won. The defendant said, no, we want to continue today. And the judge said, no, you don't make the rules, I do. And then the jury sided with the defendant. And he's like, I'm doing it because the jury said to do it, not because you did. Wife reads to you? Yes. Of course. She loves to read. She's read like audiobooks, recorded audiobooks. Have AI read your book to you. I have not found an AI yet that can read a book properly. This judge could. He's got a sing-songy voice. Sometimes he uses it. Let's hear if he uses it in the reading of the jury instructions. I predict this will be a quick.
All right, we now recall cause number 23, CR 727, the state of Texas versus Raymond Pickles. The defendant is present. The state's representatives are present. Have the parties had an opportunity to review the jury charge here for this punishment phase? And are there any corrections or changes to it? First state.
Nothing for the state, Judge.
And Mr. Peebles, any changes?
I don't care about what y'all do. Just get it over with.
All right, bring the jury in then.
I don't care about what y'all do. Just get it over with, he says. Fish stick record. British man eat 15 fish sticks in 60 seconds to secure Guinness World Record. I didn't know that was the record. I broke that record just having dinner the other day, I think. I'm pretty sure. My daughter made fish sticks, and it was a race. The race was on. Josh, I'm sorry. You've missed. This has been a great day. This whole trial's been good. Jury's here and seated. Judge, take it away. 3, 2, 1, and action.
All right, the record shall show that the jury is seated in the courtroom. Ladies and gentlemen of the jury, at this time I'm going to read to you the jury charge for the punishment phase of this trial. And again, please continue to observe the instructions previously given to you. As before, this charge will be left with the jury and your foreperson, so you can refer to as necessary during your deliberations. Members of the jury, you have found the defendant guilty of the offense of aggravated assault against public servant as alleged in paragraph 1 of the indictment. Paragraph 2 of the indictment further alleges that the defendant was previously convicted on or about April 22nd, 2021 in cause number 16-24808 for the offense of aggravated assault in the Criminal District Court of Jefferson County, Texas. and that this conviction had become final prior to the commission of the offense for which you have now found him guilty as indicted, the first-degree felony of aggravated assault against public servant. To this allegation in paragraph 2, the defendant has entered a plea of untrue. It now becomes your duty to determine if these allegations are true or untrue, and to set the punishment in accordance with the law. If you believe from the evidence beyond a reasonable doubt that the allegation in paragraph 2 is true, you should so state in your verdict and assess punishment for the commission of an enhanced first-degree felony. If you do not so believe, or if you have a reasonable doubt thereof, you should find the allegation in paragraph 2 untrue, and so state in your verdict, and thus assess punishment for the commission of a first-degree felony. First-degree felony punishment. Our law provides that an individual adjudged guilty of a first-degree felony shall be punished by confinement in the institutional division of the Texas Department of Criminal Justice, in other words, prison, for life, or any term of years not more than 99 years or less than 5 years. In addition to imprisonment, an individual adjudged guilty of a felony of the first degree may be punished by a fine not to exceed $10,000. Enhanced first-degree felony punishment. Again, this would apply if you deemed that the prior conviction was proven true to your satisfaction. Our law provides that an individual adjudged guilty of a first-degree felony who has previously been convicted of a felony, and this would be a felony above a state jail felony, shall be punished by confinement in the institutional division of the Texas Department of Criminal Justice prison for life, or for any term of years not more than 99 years or less than 15 years. In addition to imprisonment, an individual adjudged guilty of an enhanced first-degree felony may be punished by a fine not to exceed $10,000. You see the difference between these two? If it is not enhanced by a prior conviction, it's 5 to 99 or life with a fine. If it is, it's 15 to 99 or life for imprisonment,
So it is life.
And then $10,000, up to $10,000 in fine. Good time credit and parole. Under the law applicable in these cases, the defendant, if sentenced to a term of imprisonment, may earn time off the period of incarceration imposed through the award of good conduct time. Prison authorities may award good conduct time to a prisoner who exhibits good behavior, diligence in carrying out prison work assignment, and attempts at rehabilitation. If a prisoner engages in misconduct, prison authorities may also take away all or part of any good conduct time earned by the prisoner. It is also possible that the length of time for which the defendant will be in prison might be reduced by the award of parole. Under the law applicable in these cases, if the defendant is sentenced to a term of imprisonment, he will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less, without any consideration of any good conduct time he may earn. If the defendant is sentenced to a term, and this is not going to apply in this, but it's the law and we've got to go through with it. If the defendant is sentenced to a term of less than 4 years, he must serve at least 2 years before he is eligible for parole. And once again, that is not applicable under this set of circumstances because the minimum is higher than 4 years. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law and good conduct time might be applied to the defendant if he's sentenced to a term of imprisonment, because the application of these laws will depend upon decisions made by prison and parole authorities. Now, you may consider the existence of the parole law and good conduct time. However, you are not to consider the extent to which good conduct time may be awarded to or forfeited by this particular defendant. And you are not to consider the manner in which the parole law may be applied to this particular defendant. And of course, that's because those decisions are made by other authorities. General instructions. The attached verdict forms are supplied for your use. When you have reached your verdict, your foreperson should fill in the appropriate form and sign their name as foreperson. In arriving at your verdict, it is not proper to fix the punishment you assess by any system of averaging. Your verdict must be determined only by a full, fair, and free exercise of the opinions of each juror based upon the evidence presented. Your verdict, as before, must be unanimous. Your failure to follow the law contained in this charge could result in a mistrial being declared, and your deliberate violation of these instructions could result in your being held in contempt of court. Okay. We have two sets of jury instructions, and each of them have four
options. What just happened? Judge, you're frozen.
Review and determine which is applicable based upon your decision on the prior conviction, whether that's been proved or not. The first set, and
he's fantastic.
This is if you believe that the prior conviction has been proven. First option is we, the jury, find that prior to the commission of the offense for which we have found the defendant guilty, the defendant was previously convicted of a non-state jail felony offense as alleged in the indictment, and assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice. I will refer to that as prison from here on, for a term of blank years. And that would be no less than 15 nor more than 99, a place for the foreperson to sign. The second option of this bundle of four, we, the jury, find that prior to the commission of the offense for which we have found the defendant guilty, the defendant was previously convicted of a non-state jail felony offense, that is something above of a state jail, third or higher, as alleged in the indictment, and assess his punishment at confinement in prison for a term of years, no less than 15, no more than 99. In addition to such imprisonment, we assess a term of blank dollars not to exceed $10,000. Third option, we, the jury, find that prior to the commission of the offense for which we have found the defendant guilty, the defendant was previously convicted of a non-state jail felony offense as alleged in the indictment, and assess his punishment at confinement in prison for life. And the final fourth option, we, the jury, find that prior to the commission of the offense for which we have found the defendant guilty, the defendant was previously convicted of a non-state jail felony offense as alleged in the indictment, and assess his punishment at confinement in prison for life. In addition to such imprisonment, we assess a fine of up to $10,000. Only one option of the four on either set can be signed. Does everybody understand? Everybody understand your four options here? And the next set are based upon whether, if you believe that the state has not proven beyond a reasonable doubt that the defendant was previously convicted.
They have.
They have. He's like, what?
Sir, you just made an outburst. Again, an inappropriate outburst. Please don't do that again, sir. Thank you. These four, again, we will go over them, ladies and gentlemen. The first option of these four, we, the jury, find the defendant has not been convicted of any previous felony offenses as alleged in the indictment, and assess his punishment at confinement in prison for a term of blank years, no less than 5 nor more than 99. Does everybody understand the distinction here? Place for the foreperson to sign. Second option, we, the jury, find that the defendant has not been convicted of any previous felony offenses as alleged in the indictment, and assess his punishment at confinement in prison for a term of blank years, no less than 5 no more than 99. In addition to such imprisonment, we assess a fine of not to exceed $10,000. Everybody sees the difference there. A fine is applied on this one if that's your choice. The third option, we, the jury, find that the defendant has not been convicted of any previous felony offenses as alleged in the indictment and assess his punishment at confinement in prison for life. And your final option, we, the jury, find the defendant has not been convicted of any previous felony offenses as alleged in the indictment and assess his punishment at confinement in prison for life. In addition to such imprisonment, we assess a fine of blank amount.
So
only one
5
verdict
to
form
5 to
can be
99
signed out of these 8.
or life.
Does everybody understand the
and
distinctions?
fine up to 10,000.
All right. As before, the state of Texas may open and close final arguments. What says the state?
Once again, Judge will waive a right to open reserve right.
You may. Mr. Pickles,
Last
you
chance.
may present your argument to the jury.
Wait, my wife.
All right. You're doing that voluntarily and because that's what you want.
That's what I want.
Oh, then the state may go forward.
I'll be brief since we don't have, we're after hours here. I think it's pretty obvious when you look, and you can even take these back with you if you want to. The allegation alleged in the indictment that states he did it number 40, if you need to look at it, which is the actual assault, which was the actual conviction occurred before he committed this offense and was convicted of it. So makes it 15 to life. And that's what we're asking you for. And I think you need to, I feel really bad because whatever I ask you to do, I'm going to put you back. I'm going to put him back with those jailers. They have to put up with him. But he talks about the fact that, well, first of all, he says he does so well in prison that that's where he doesn't commit any other of these offenses, that he says he does well and he's out in free population. So you're actually doing him a favor of getting him out of isolation and putting him in prison. And I hate to say that, but because it is punishment. And I'm asking you this because I want you to think about this. First of all, he's right. He was placed on probation, I'll just do it this way. He was placed on probation. And if you look at this, you'll see that back here on the signatures is not only the Raymond Peoples signature, but my signature. I gave him a chance. Back in 2016, I gave him a chance. I said, if you'll own up to this and you behave yourself, you can get out of this without a conviction. You get probation for 10 years. And if you're really good, you can get off probation without a conviction. He couldn't follow the rules. And that seems to be a pattern with Mr. Peoples. Because he doesn't want to follow rules. He wants to control everybody. That's what he wants to do. Because you said he wants to control everybody.
I'm sorry. Hold it. Sir, you cannot make outbursts. You gave up your opportunity to make a final argument. He has a right under the law without interruption to make his final argument. So please follow the rules, sir. Go ahead.
He cannot follow rules. And the problem is with this is that it's kind of funny when he does it in here. But when he does it in a jail setting where there's weapons or he's got things that he can hurt people with, or where he throws species on them or does things to them to just totally make everybody's life miserable. Plus,
Careful. You've got your
got
back
other
to him.
inmates that he's throwing things on. He's trying to escape. He's doing all these different things. It's not funny. This time it's not so funny is because he's facing 15 to life and it's serious, and yet he's still here making all these comments because to him it's just a game. Everything in this is a game. It's not about anything to control. It's all about Mr. Peoples. So what I'm going to ask you to do is I'm going to ask you to make this sting, because he was serving a 20-year sentence when he did this, and evidently that doesn't scare him one little bit to serve a 20-year sentence. He's asked you a while ago, he told you just go ahead and give me a life to send me home, and that's up to you. But I'm asking.
That's what it is. I'm telling you.
I'm sorry, sir. The second time I've had to scold you on making outbursts during a time that he is not to be interrupted by law, just like you were not to be interrupted if you wanted to make your closing argument. Please follow the rules. Again, I state to you, please follow the rules.
He's about to get zapped.
That an individual can't just do what he's asked to do. I mean, it's real simple. Just move here, do this, remain quiet, follow the rules. But he has to be in control. And we talked about that in board hour. People have to be in control, and he's got to be in control, being his own lawyer. He's got to be in control in this courtroom by stopping and saying, And I let him have his free reign. Y'all saw that I did that. When he got up there and said, I let him have his say. And I wanted him to have his say. I wanted him to be able to tell you everything he wanted to tell you because you realize who he is. Because you had already.
Sir, this is the third time during the final argument you have interrupted the attorney. And again, do not do that.
So
there's a buttons.
Y'all go back there. You know that enhancement's been proven. So following your oath, you find it true. And the first 4 pages that you see of their verdicts is what you're going to be looking. And you're going to ask me to give you something. I'm just going to ask you to give him a really good bump up from 20 years because of the fact that he was serving 20 when he did this. And that doesn't seem to affect him. So he needs to get a little spanked a little bit harder to make sure that he understands that he's not in control. He is not in control.
For the record, that's the 4th time that the defendant has defied the court's order and has interrupted the prosecution who is giving his final closing, which the law says he can do without interruptions, unless you want to make a legal objection.
That was a legal objection.
That was not, sir.
Objection. For pointing the gun.
Proceed.
30 years to life.
Sir, your objection's overruled. Proceed.
See, the problem is you wake up every morning and you see violence out on the street. And so what do? We put them in jail. And we trust them to people that they come up here and they try to do their best to watch these people. And what does he do? He creates the violence in the jail. You can't seem to stop him from doing that. So there's only one place to go, and that is someplace where he's going to be controlled by some state people that will have more resources than our county jail to keep him there, to keep him under control. So I'm asking you to at least double what he got before, from 20 to 40, to make sure he knows that this is not the right thing to do, to treat people the way he treats people, and he's not in control.
I'm surprised he's not.
Thank you for your time.
And ladies and gentlemen of the jury, at this time, I'm tendering the jury charge to the bailiff. I ask you to please follow your 4-person into the jury deliberation room. We will await your verdicts. And alternates, thank you for hanging in there with us.
Y'all feed up this man sleep at night.
Sir, you're going to have to muffle him. He can't be speaking to the jury as they're leaving like that. That's improper.
Gag? We went with the ball. We went with the gag? I think the prosecutor was hoping that it would stir a reaction from him.
Please note that was the 5th time the court had to scold the defendant for making outbursts at closing during the state's closing.
You muffle someone by
that is all. We're in recess. We're in recess.
What else can you do wrong? What else can you do? How else can you do it? Keep your isolation for another 12 months? Congratulations, Mr. Laird.
He just congratulated the prosecutor. We have a timer going. They've been back 50 seconds so far. They might be done. They might be done right now. It might take longer to get the note to the judge than it takes the jury to reach a conclusion in this one.
He's going to handle his own appeal.
Oh, is he busy?
Oh yeah,
That's
he's got like 3 writs pending here. I think he's got 2 pending. He's filed stuff with the Supreme Court. He's filed stuff with the Court of Criminal Appeals. They've all denied everything he's done, but he keeps filing.
Yeah.
They call him the serial filer. I'm sure he'll keep filing. You're kidding. No. Every time he calls, he goes, well, why do you deny this? This is on Mr. Pickles. Which one, first of all? He goes, we denied the first 2, and then the second one's still pending, but
Can we all just go out and get happy hour? I second that.
Yeah.
And I don't drink. Me neither, but I second that.
She just
Well, I'm
said,
gonna just watch other people drink.
Well, you know, hey, that's what's more fun.
can we all go out and just get happy hour? She says, and I don't drink.
I don't know. Oh.
It's sad because time now, you keep texting. Bosses are watching.
It was muted, was it?
Hot mics, hot mics. Mrs. Zero Fun Sir comes in and turns the mic off for us. Says, "Poop, I meant to send you a trivia card, but my grandmother fell ill suddenly. I'll get on that as a great distraction." I'm sorry your grandmother fell ill. I'm sorry to hear that. Thank you very much for the super chat. What did he say at the jurors? He wasn't saying something at the jurors so much as he was he was going into the back where the holding cell is for him, but the jurors hadn't yet gone into the deliberation room. And so they were waiting for that door to close. So they held him right there. And while they were holding him, he looked back over at the prosecutor and said, "Congratulations, Mr. Laird." I think Laird or something, whatever his name is. He congratulated him on the win. I guess that's acknowledging. Is that a concession speech? I guess. But when we get the verdict here in just a moment, which I believe we will, I'm thinking under 5 minutes. When we get the verdict, he did tell the jurors, "I hope you can sleep at night." Yes, there was that part as well. I'm sorry. Thank you, Exo Cherries. That was before he was told he needed to be muffled. Let's see. She put it on the wrong camera. The jurors are shown on multiple cameras. Let's see if we have a verdict here. We need, I got the music queued up. Watching for the light. Timer's at 4 minutes, 20 seconds. I honestly think it's going to take 5 minutes just to get the judge a message to the bailiff. Knocking on the door, get their attention, send it to the bailiff. The bailiff takes it, hands it to the judge. Judge takes it, reads it, comes in. This one's done. It is Mr. Laird. Thanks, Red Pen. We needed that name. Let's see. Prosecutor goes back. I think it's 10 minutes. I think 12 minutes, including the potty break. I don't think they need another potty break. We've had sharp breaks all day long, and all those sharp breaks add up to one big long break. Do you have some crazies in Texas? This is one of them. This has been a not-so case. I wonder if the jury is going to... You wonder if the jury feels bad and is going to do just what the prosecutor asks, or if the jury feels like, you went easy on him, and they exercise their right or their authority and say, this we need to actually do more than just 40 on this. This guy does not deserve another shot ever. They could go life on this one. Sloth Life. This trial in the commentary has been a brilliant distraction. I need to double bypass. Oh my goodness. Multi-disc team meeting to see if other health issues will prevent surgery. Get answer 11th of August. Oh my goodness. Sloth Life. We'll be keeping you in our thoughts and prayers. And I'm glad this distraction helped. Hopefully the laughing, deep belly roll laughs was therapeutic and helpful to your spirit, if not to your ailments as well. So it's good. It's good for the soul. Laughter is. We'll keep you in mind. Thank you so much for sharing, and so sorry you're going through that. There's short, sharp breaks because there's no reading material in the bathroom. I think they're out of toilet paper as well, quite honestly. Sloth Life as you can see, a lot of people in chat are have you in mind right now. Do keep us in the loop. Slothlife's been a long time major supporter of the channel. You're wonderful. We miss you when you're not here, even if we miss you when you're lurking. Let's put it that way. But we understand for sure. We have had plenty of poo talk. Plenty. I think we're done with number 2 for the week. Thank you, everyone. Laughter has really been the best medicine. I was RFOL laughing at RA yesterday. Oh my goodness, yesterday was nuts. So it was wild. I'd rather be here in the junior high boys locker room than over at the Clancy trial. Oh my goodness, I'm catching snippets. You guys know I follow all sorts of court cases all throughout the day. I'm catching snippets of what's going on, and it is heartbreaking. That case, it just hurts. It just makes you want to cry. I mean, just like not just like a tear roll down the cheek, but just curl up in a ball and an ugly cry. It's terrible. It's terrible. Hey, Mrs. Ari, how are you doing?
Good. I need that address that was sent to you.
Oh, do you need my phone? Okay. Thank you. I appreciate that. How was the water park?
Good.
Yeah. Did you go down the big slide? No. All right. Trial is tough on all accounts. It's the best medicine for me on this channel. Watching court with this community is amazing. It truly is. Obviously, we have a healthy level of respect for the courts, but at the same time, we've got a lot of representation for the defendant's rights, the presumption of innocence, the defense side of things, that other viewpoint, and I love the mix that we find here. It's wonderful, and there's some great channels out there that are covering some heavy trials, and so if you're watching with one of them, more power to you. That is wonderful. We're going to be in a big case, hopefully as soon as next week. If Sarah Grace happens, bring us there. Anyway, I forgot where I was going with that, but this community is amazing. Thank you all for being what you are and making it what it is to watch court together. Judge, it's been 10 minutes. It's 9 minutes and 50 seconds right now. Do we have a verdict? Is this a harder decision? Watching with the Matas, there's a good place. This trial should count as everyone's colonoscopy. Oh my goodness. We're all friends here. No enemies. Enemies, excuse me. Yes, the Tai Chi lemur. I appreciate that. If only Men in Black were real, they could use one of those forget rays on Mr. People, so we forgot whether he knows and he could be free. Well, just flash the memory and reset them back to being law-abiding citizens. That sounds like a movie plot. Nah. The good guys dress in black. Remember that, just in case we have a face-to-face and make contact. Now, that was a good movie. Good old Will Smith with the rap. I don't rap, obviously, as you guys know, from the big deal. Let's see. Is this part 6 or did I skip part 5? Can somebody tell me? Or is this part 4? I think I called this part 6. Only because it seems like we've been here that long. Does anyone know what it actually is? And by part, I'm talking about times that we were live and then we took a break for lunch and then came back, or took a break for the end of the day. You skipped part 4 and you called this part 5. So let me fix that and call this part 4. For those people who are dying to get every minute of the poop coverage. It's now part 4 here. I fixed it. It's 4 now. It said 5. All right, we are just now. We're at 12 minutes. We're basically right at the moment when we had a verdict last time. This one might be a little harder. You know, it's one thing to say yes, the law finds you guilty. It's another thing to say this is how long you will be incarcerated. This is something that the jurors should not take lightly. Taking away someone's freedom is a big deal, and determining how long that should last is a decision that will stick with them for quite a while. We're all a little run down. Yep, we're all a little run down. I sort of lost a bet with myself. I was thinking for sure this would be the case where we would see live on TV the defendant get zapped with the stun gun, which he showed to the jury while he was on the stand. So far has not happened, but if the jury comes back with a life in prison, at that point he literally has nothing else to lose, and I would be concerned. Quick check of the channel. Let's see if we have, in fact, made it back up above the 73,000. Nope, we are still 8. We're losing viewers on this case. We're now 8 subscribers short of the 73,000. It's all right. It goes up and down. How much time is he doing now? He's 7 into a 20, I think. 7 years into a 20-year sentence. And he's picked up a whole bunch of more charges. He's got a case that was just filed last week as well. Was it the poop jokes? Maybe. I think so. Which sound clips do we choose from this trial? There's one. There's one I want to get. I don't remember, but it's at the very end of the previous recording. So I'll pull the tape and find it. It was a good one. I know there was a... Was it Mother? Mr. User, thanks for hitting the subscribe button. Mother told me there would be days like this. Yes, that's it. Mother. I think I've got that one. The sharp break is the one I want. I'm not sure if I want to introduce toilet humor on the regular. Like every time we break, someone's going to click the sharp break sound effect. Can we get an original RA song about this trial, please? Rachel B, I like that idea, but if we do, it's going to have to be somebody beatboxing that goes... That has to be the beatboxing. And I'm sorry, I'm not a beatboxer, but it has to be basically fart sounds for the beat. So if you want that, we can put that together. Let's not. Don't do it. It's basically whoopee cushion sound effects throughout the whole thing. Hard pass. Yeah. It could rise to number 2 in the charts. You never know. I mean, I don't think it would be a number 1 ever, but it's got potential. Oh, yeah. Are we on Verdict Watch? We are on Verdict Watch for sentencing. Kendra Daly, thank you very much. Welcome to the gallery. I see the blue courthouse, which means you're progressing on to that 2nd or 3rd month of membership, but I appreciate your support. It means the world to us. We could not do it without support like yours, and thank you very much. Thank you. You can never leave, though. You're one of us. We've now exceeded the time limit. We're 60 minutes, 45 seconds into the deliberation. jury needs to get this figured out. They do not want to come back again tomorrow. And look at that, a little peek out from the bailiff. We might have some motion, might have some movement in the back rooms of the courthouse. We're trying to experience our after dark. Dance skills. I have 0 dance skills, like none. I think you guys know that. The only thing I can do is, back in the day, I could do the in sync, like the boy band, where where they're all standing with their back face towards the audience, and they're like bye 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 bye, and on that bye bye, when it hits the beat, they all jump and turn. I can do the jump turn. That's it. So, loves true crimes. Oh my goodness, another huge super chat coming through. Thank you for that. I love that. Can I click? I think I clicked the heart button on that. Thank you. You can do anything with practice. That's the problem. That's the problem. I refuse to practice dancing. I'm worried. There's still a part of me that thinks that this defendant is now super frustrated. He's aggravated by the situation, and just might act out. I would be surprised if they uncuffed him or kept him uncuffed at this portion of the trial. I realize they've got the taser strapped to his leg, but I think they need to take some precautions for the safety of the jury and the prosecutor and the judge. I think the bailiffs are all right. They have a good rapport. Ride the Lightning. Is that a Metallica reference? Is the back of the judge's chair have an insignia, or is that from head bumping? That is the logo, the Texas state seal, has sort of been painted or etched or burned onto the leather. It might have been bleached onto the leather. I don't know. I don't think we can talk about bleaching in this case. Very early Metallica for Ride the Lightning. Originally from The Stand. Didn't know. I thought it was before my time. Mrs. Golden Rule, thank you very much. Enjoy. Little Alabama. Crimson Tide. Support there. When does football season start? Do we have a couple months? A couple more months? Fall, right? I think he would be in cuffs for this phase when he comes back out. At least there better be a bunch of huge bailiffs surrounding him. I have noticed that the tables that he's sitting at cannot be flipped. They are, in fact, bolted to the ground. Ricky C! Thank you, Ricky. Thank you for all you do and don't do. You help my mental health a lot and make work go by faster. By the way, our After Dark is cool and hilarious, too. We might have to do some After Dark. We'll see. We'll see what happens. We'll see what happens. Thank you, my friend. Appreciate that, Ricky. Also another huge supporter on the channel. Very generous, many members due to some of the names you've seen on the screen here today. Many memberships have been gifted for that reason. End of August for football. All right. 20 minutes in. 21 minutes now. Maybe the jury has a little disagreement on the length of time. And now the judge comes out. Kazam Cat. 35 months makes you an OG. I think they're saying bring the defendant. Tried to read lips here. It's not working very well. Judge talking to the bailiff and court staff. See if he resumes his perch. Zamcat, thank you very much. 35 months. You get a new color courthouse next month. That's exciting. Bailiff now blocks our view. We can't see if the judge leaves or is still standing there, sort of between his chair and the door. Security has locked us in for the night. One of you has to watch Mr. Peoples. The judge says 1, 2, 3, not it. The jury's like, we want dinner. We want dinner. This trial has been a great weight loss trial. Most of us unable to eat like we normally would due to the testimony. Tumwater Troy, thank you very much. Welcome back. We're just shy of 300 votes. We're at 287 right now. We could get another 13. That would put us at the 300 mark. Buffer, what's happening? Loves True Crimes. I think only the mods can trigger that one. But did you have something? Did I miss something? With someone like this, you might have to split the baby. About 15 years added, sends a message without throwing him away, so to speak, leaving him to teach law well inside. Oh, can you imagine all the cases that are going to come from this one as he starts taking clients there in prison?
With more experience.
Tomato sandwiches. Tomato sandwiches. Do you use Velveeta on tomato sandwiches? Because growing up, I realized Velveeta. Some people think of Velveeta as like a glorified plastic. Other people treat it as the heavenly gift that it is. My first exposure to Velveeta was using it as fishing bait for catfish in Willard Bay. I don't know if it worked. I don't remember catching any fish. But no, it's buffering. Having some internet issues. I'm doing all right on this end. Looks good over here. Anyway, tomato and pepper and a slice of Velveeta cheese. But you actually have to do like a slice and a half of Velveeta cheese because Velveeta only covers like 3/4 of the sandwich. So you have to also cover the top and the side because it's square. You want me to eat bait with my gorgeous sun-ripened early girl? I thought you were going with like, isn't there like a fat boy tomato? Mayo, lots of pepper. I struggle eating tomatoes, and I love ketchup, right? I love all things tomato sauce. Mush it up, and it's great. But just a tomato in its regular form, it's the gel around the seed that gets me. Nope. I like a salsa, fresh salsa. But mayo, onion powder, pepper, beefsteak, tomato. Beefsteak, oh, those are good ones. Those are good. Ripe avocado, whole grain mustard, maybe a little bit of honey Dijon or Grey Poupon, maybe. Beefsteak tomatoes were good. I eat tomatoes like apples. Lacey. I've never seen anyone do that. Other than like a cherry tomato or even sometimes a Roma. I want to make salsa very badly, but I'm nervous with all the lettuce and veggie issues going on. I picked a 2-pound tomato from my garden. That must have been a beefsteak. That must have been just a monster. Going to Red Pens for dinner. I'll bring the Velveeta. You try it. You got to try it once. Who puts lettuce in their salsa? Not me, but I'm just saying with lettuce and all the other fresh vegetables that we've got these warnings about causing tummy trouble, like this case. I just hesitate to buy a bunch of tomatoes and peppers and everything else that's grown in the fields and picked and might be contaminated. I think the high acid of salsa and the high heat might make it okay. Well, I'm doing fresh garden salsa, so it's cold and fresh. Someone just took a candy out of the candy bowl. Here we go. Judge, hit the button. Hit the button. I think we've got movement for sure. He says, come in. Do I hit the button? Let him say it officially. 3, 2, 1.
All right, we have a verdict on the punishment phase. Stand by, please. Stand by. Thank you.
Well, shoot. It took less than half an hour. Sorry, that just about slipped out. It took less than half an hour for the jury to reach a verdict in the punishment phase. 28 minutes and 25 seconds is what I have. And here we are once again with verdict music playing as the jury has reached a conclusion in this case. By conclusion, they want this to come to an end. It has been a mess. It has been it's been a show. It's been a cluster. It's been everything. It's been a circus is what it has been. Nobody wanted this case to come to an end more than the judge himself, Judge Stevens, who has displayed the patience of a patron saint of patience, whoever that is. Who's the patron saint of patience? Judge, what's her name? From up north. Anyway, the jury's going to be coming back in with the verdict. The defendant has displayed increasingly hostile behavior towards the court. There's a chance here we might end with fireworks. By fireworks, I mean sparks. So those sparks would come from the ankle of the defendant who is wearing a shock collar attachment. He's displayed it to the jury already. We know it's there. We know it has the capability. And we know he also has the capabilities. We've seen him on video acting out when he doesn't get his way in jail. And once again, he has not got his way here today. The jury has already found him guilty. He's now deciding whether to sentence him to 15 years to life.
We've received the verdict on the punishment phase of this trial, and we will bring the jury in to receive the verdict.
Thank you, Judge. We're waiting for the jury right now. One, two, three. Jury's coming in now. This is a jury of his peers. They look exhausted. They look pooped. Let them take a seat.
And the record shall show that the jury is seated in the courtroom. And Mr. Stanley, as foreperson of the jury, we've received a message on your behalf stating that the jury has reached a verdict in this punishment phase of this case involving Raymond Pickles and cause number 23CR727. Is all of that correct, sir?
Yes.
Is this verdict a unanimous one? That is one that is agreed upon by all members of the jury?
Yes.
Any of the jurors disagree with your foreperson's representations? No disagreement is indicated, and it does indeed appear to be unanimous. As before, if you would pass the documents to the bailiff, I will review the proper form and publish the verdict.
There's only one form that should be filled out.
Only one assigned, and y'all did that right. All right. The defendant shall rise. In cause number, the defendant is refusing to rise.
Buzz him.
For the record.
No, just kidding.
In cause number 23 CR 727, the state of Texas versus Raymond Pickles, we, the jury, find that prior to the commission of the offense for which we have found the defendant guilty, the defendant was previously convicted of a non-state jail felony offense as alleged in the indictment, and assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 40 years. Signed by the jury foreperson. The verdict is received and made a part of the record for all purposes. Ladies and gentlemen of the jury, at this time, your duty as jurors is completed. At the beginning of the trial, I placed each of you, releasing you from all those instructions previously given to you. However, one final instruction. Once you are discharged, you are released from your oath of secrecy.
We're having some hiccups from court. Let's see if this will get cleared up on its own. Might be having some bad weather up there, or maybe just the servers are updating because it's after hours. That's weird, where I know the judge is frozen, but the defendant is not.
Once you are released, you are free to discuss these matters as you choose and free not to. I want to thank you for your service as jurors, and it's the way the Constitution works. We, the people, get to make these decisions on other people's lives, and I think that is the proper way to do things. I hope to have the honor to work with you in the future. May God continue to bless Jefferson County and her citizens, and you are excused. Thank you. You were going to have documents?
If they'll wait for me out front, I'll have their excuse letters for work or school.
Okay, she'll be shortly. Thank you. Yes, ma'am. Stand by.
Off the record, just a quick little talk with some court staff. Like, Judge, I need to go home. I've been here 12 hours. Let us back in, Judge. There we go. Toodles, he says.
Thank you, sir.
Toodles to the jury.
Thank you.
And a thumbs up. Can we uncover the camera?
All right. In 23 CR 727, is there any legal reason why judgment shall not be formally assessed at this time? State or defense? No response from Mr. Peoples. Mr. Peoples, Raymond Peoples, you came before this court and a jury, entered a plea of not guilty to the offense as set out in the indictment. The evidence was submitted. The jury was charged by the court. After deliberating, the jury returned a verdict finding you guilty of the first-degree felony of aggravated assault against a public servant. Thereafter, evidence was presented on the punishment phase. The jury was instructed on the law on punishment during their deliberations. After deliberations, they assessed punishment at 40 years confinement in prison. It is therefore the judgment of this court that you are guilty in this cause number 23 CR 727, and you shall be punished in accordance with the jury's verdict. Is there any legal reason why sentence should not be pronounced against the defendant by either party?
You asked that already.
Finding nothing to bar the pronouncement of sentence against you, it is the order of the court that you, Raymond Peoples, who has been adjudged to be guilty of the offense of first-degree felony of aggravated assault against a public servant in this cause number 23 CR 727, and whose punishment has been assessed at 40 years confinement in prison in the Texas Department of Criminal Justice's Institutional Division, shall be delivered by the sheriff of Jefferson County, Texas, to the director of the Texas Department of Criminal Justice's Institutional Division, or any other person legally authorized to receive such convicts, where you shall be confined for 40 years in accordance with the laws governing the Texas Department of Criminal Justice's Institutional Division. Stand by.
Consulting the big book. Breaks up the yellow pages. Pizzeria.
Under Article 42.08 of the Texas Code of Criminal Procedure, the law states if a defendant is sentenced for an offense committed while the defendant was an inmate in the Texas Department of Criminal Justice and serving a sentence for an offense other than a state jail felony, and the defendant has not completed the sentence he was serving at the time of the offense, the judge shall order the sentence for the subsequent offense to commence immediately on the completion of the sentence of the original offense. What does the state say?
Concurrent.
Judge, it's pretty clear that this person was, Mr. Pickles was serving a 20-year sentence and was still under the custody of the Texas Department of Criminal Justice. So it's mandatory to be stacked. We'd ask that you stack it on top of this prior sentence in files number 16-24808.
Consecutive. One after another.
All right. Your objection is made. It is overruled. The law is clear. Under Article 42.08. So you were hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 40 years. And that sentence of 40 years shall commence immediately on the completion of the sentence for 3 years. You're going to have to stop him from speaking so we can complete this. As obstreperous as he'd been through the whole trial, he continues to interrupt the court.
She's grabbing the buzzer.
The judge, under the law, orders, and this is cause number 16-24808.
That's correct.
That the court finds that the defendant was an inmate in the Texas Department of Criminal Justice serving a sentence for the offense of aggravated assault, a second-degree felony, convicted on April 22nd, 2021, in cause number 16-24808, in a conviction in this criminal district court of Jefferson County, Texas. He has not completed the sentence he was serving at the time of the offense that he has now been convicted, this first-degree felony of aggravated assault against a public servant as adjudged by the jury. Thus, the judge is ordered to sentence the defendant of this subsequent offense. He has now been found guilty in 727, which was committed subsequent to the conviction he received in cause number 16-24808 of the second-degree felony of aggravated assault. The judgment shall state that this offense here, the sentence in 23 CR 727 of 40 years confinement in prison, shall commence immediately on the completion of the sentence the defendant is serving in cause number 16-24808, the aggravated assault second-degree felony. And thus, this sentences shall run cumulative or consecutively to each other by law. The defendant will be given credit for all time he has served in accordance with these sentences, and that is the finding of the court, and that is the ruling anything else to add, state or defense, we're in recess. You are here, you are now remanded to the custody of the sheriff of Jefferson County, Texas, until she can obey and carry out the directions and instructions of this sentence. That is all. And please note that the defendant was shouting over the court as he is being led out, as the court is trying to read the formal sentencing and a judgment as provided by law. And again, throughout the trial, the defendant interrupted, refused to follow orders of the court in proper, so that the proper order of the proceedings could be made. His attempts throughout this trial to interrupt and were allowed for the most part by the court, although the court would attempt to instruct him not to do that. That never stopped him to the very end as he continued to interrupt the court. And also his defiance to court rulings throughout this trial also were multiple, as it's obvious that the defendant was not about to follow the rule of law nor the orders of the court. The court attempted, though, to give him more leeway than the court has given to any other defendant out of the court's history of 616 jury trials in this courtroom. But nonetheless, the defendant to the very end acted obstreperous and defiant of the rulings and orders of the court, and
go on, Judge, get it out of your system.
Interrupted throughout the proceedings. And this court even allowed him to make lengthy narrative statements during his presentation of the evidence, which were not in a question and answer method to a witness, but were his long narrative complaints about the processes that he was claiming to endure while being an inmate. All of that is clear in the record, and the court was attempted numerous times to allow the defendant chance after chance to correct himself, and to the very end, he continued to interrupt, defy court's rulings, respond in defiance to the court's rulings.
We're going to do round 2 on the song.
And thus, this was a case that had a lot of interruptions to it. All right. And all due to Mr. Peebles' defiance to orders and rulings, and defiance to just decent standards of respect to other parties and to each of the participants in the trial.
The judges let this just build up.
We are now in recess.
For all
this,
that.
Is going to, the judgment's going to be stacked on top of each other.
Okay.
Okay. Anything else? Then we are in recess. Thank you.
We'll see you, Judge. Did a great job on this one. All right. There you have it. That brings the case of Mr. Poople People, the Poople People Eater. The Mr. People. To a resounding close, as the judge just lets all that resentment that's built up inside him just vacate. He has to let it out. You can't hold that inside, Judge. It'll just tear you up inside. Vents to the record about the behavior during court. He says, in all my years, 616 cases, this has been the worst, and you were here for it, guys. Thank you very much. Can't wait to move on to more uplifting less stinky subjects in court. So we'll do that. Tomorrow is podcast day as well. So tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning. We'll see you then. Thank you all for being here. You guys are amazing. Thanks for your incredible support. You guys are wonderful. Thoughts and prayers for all those who have shared the concerns and things that are going on in their life with right now. We're thinking and praying about you as well. So you guys, everyone, we'll see you tomorrow. Until then, be safe. Go wash your hand. Go clean the bathroom, maybe. That's what I think I'm going to do. Just clean the bathroom. You guys have a good night. We'll see you.
Thank you, sir. You're my new best friend. There's nothing in the order that restrains you from talking to cats.
Don't miss the forest for the trees.
Take order.